not been extended to the petition number
That is
6.
an offer made by the Advocate General. of the
Yes, my lord.
state.
Yes, my lord. Then later
No
on, my lord.
direction has been issued by the court.
Yes, my lord. Then if I come to para number 22, that is on page number 36, my lord.
Hmm.
Well, in para 35 second last line, my lord, it is therefore observe that
Yes.
having regard to the fact and taking into account the other fact situation, that in any event, any of these petitioner prefer any application for allotment settlement of land under the provision of land policy 2019 before the competent authority as per the procedure on the basis that they are deserving indigenous landless person, the competent authority shall undertake a fact finding exercise to find out the eligibility or otherwise of the applicant and thereafter consider the application on its own merit as per provision of land policy 2019. Having regard to the humanitarian aspect involved, the court is also of the considered view that such exercise shall be undertaken and completed within a period of 2 months from the date of submission of such applications, my lord.
See, you go by para 22, I go by para 21. Right?
Yes, sir.
So, if you are entitled to go and file a clarificatory petition or a review. But there is no direction in view of the categorical observation or direction of the court that your petition is bereft of any merits and is existence.
I understand, my lord. I understand the
If
difficulty.
you understand, we are closing it. Hard learned counsel to the
No, my lord, give me a time, my lord. I'll take some inspection and I'll let you.
matter stands but we next it again. After
After 1 week, my lord.
the contempt petition is filed seeking compliance, alleging willful disobedience and non-compliance of the directions contained in the judgment and order dated 14/12/2023, passed in 659 of 2023. Counsel for the petitioner submits that there was a direction by the court. Consider the application. What is that?
Application for allotment and settlement of land.
Application for allotment and settlement of land.
And for one petitioner, my lord, the benefit of 3 lakh rupees and a settlement of land.
Certain other benefits have been on the certain other benefits in respect of one petitioner on the basis of submissions made by the state on behalf of the state during the court of the hearing. So, these directions were directed to be undertaken and completed within a period of application. So, however, at para 21, the courted bench made a categorical finding as expected as a such new para such matter. This court is not inclined issue notice on a writ petition complaining non-compliance whether it as indicated. However, the counsel for the some time to complete the
Much of it.
Your phone?
Yes.
Lordship, in this matter, in fact, we have been asked to take the instructions, and also I have received the detailed instructions along with the paravise comments. And from immediately going through, only now I could find out that report. So I would like to find my affidavit. Already inquiry has been constituted and inquiry report has been submitted.
The petitioner submits that you have received the instruction.
Yes.
And you'd like to bring it on record by way of an affidavit. Mr. J. Ahmed, the counsel. Yes.
That's a van for the respondent number 8, appearing on behalf of Mr. K. Bolu.
Let the matter be listed after 2 weeks,
2 weeks.
by which time the government advocate will file the affidavit as prayed for.
As far as respondent 8 is concerned, his affidavit also, he is the person, OC, I made him party by name. I filed a case against him, my lord.
Since respondent number 8 is arrayed as the party, in the present petition is arrayed by
He was the OC.
as a party respondent in the present petition. Did an affidavit filed on behalf of respondent 8. Matter within a period of days after.
Other respondent also appear, but they are very low.
May I finish? Your case is returnable today, my lord. I have taken steps in this matter.
Who's for the other side?
For many was some, my lord. Revenue department.
Yes, government revenue. Yes, who's for the government? What instructions?
In fact, we would just pray for some extra time for instruction because already they are protected by the status.
We have received notice for respondent number 4. I find my Okala number. Service otherwise.
The learned. So, yeah, for the time in the state of the instruction. I said, yeah. Here,
2 and
uh, part of court responsible court. Let the respondent complete their instruction. I said, yeah, and to be instead of 4 weeks, interim order passed again.
my
May I please, Your Honor? For office note that 17/5, participant is awaited in respect of respondent number 8. Notice were issued on.
Which on notice on respondent number 8.
Yes.
The order dated 25. Waited. And reappears for respondent number
6 and 7, my lord.
6 and 7. Let the matter be listed. It is matter be listed after 4 weeks.
Of that.
Registry to make necessary and not service.
Of that.
May I please, your lordship?
Yes.
Lordship, my senior engaged another court. So we timing.
Not time being. What is this matter? Your name?
R.I. Mandal. R.I. Mandal.
RN?
R.I. Mandal.
RI?
Mandal.
Mondal.
Yes.
Mondal appears the petition filed by non-payment of ex gratia, with which claim the entitled, which the petitioner's husband. You don't know.
So I don't know. Husband of the petitioner.
Second, duty is to state the High Court action. Consequently, petitioner claims to be entitled for compensation. Despite over entitled claim the
3 to 7.
after and let's be our one Mr. P going to respond to that the respondent of their and to be listed after 2 weeks, not 4 weeks. Find out what the status.
One thing we have put out, the case of not a case of murder. They are trying to portray as a
But notification says accident also.
Yes, but from murder it is 5 lakhs. Now they are trying to portray
Find out
Get pilot to like paying 5 lakhs.
whatever. We are not issuing notice. You get your instruction. Let the government advocates complete their instruction. The copies be furnished within a period of this week. The respondent. It will be listed after 3 weeks.
This case relating to extension of time under section 168. Lordship, we have filed a affidavit in item number.
Lordship.
Force major.
Force majeure. Lordship, in item number 69, we have filed our affidavit. We have subcopy to all the council.
We'll take it up along with the matter.
Lordship, yes,
Take it up along with the other matter.
probably
Lordship, since it has come for the first time today, notice may be issued and.
What purpose? It's only for that question only. Let us see, let us examine the matter. If required, we will notice. If he says that we have filed one affidavit, we will cover the stand of the entire respondent in respect of all matters. What for do you issue?
The affidavit has been served yesterday to me, Lordship, we need to file a reply.
Let us have a look at the matter. Mr. Gogoi,
Yes. Along with them, series,
whatever series is there, we take it up.
so total 52 cases is listed.
In which matter have you filed?
Item number 69.
69, who appeared for the petition? You appear.
My lord.
So we'll call up your matter first. Along with the other
We
matter.
need to file our reply, my lord, because,
Let us have a look what the department has said.
my lord,
You, of course, you have a right to file a reply.
My
No
lord.
doubt about it.
my lord.
Let us have a look.
My lord.
Mr. Saraf will take it up. It was 69 or no.
And my lord, item 11, 14, 15, 17.
All these matters will follow up
My lord.
together.
May I please, your lordship? This matter is relating to the seizing of the tractor lordship, the property illegally acquired property as the illegal acquired property lordship. Your lordship, the impugned notice will find lordship page number 31 lordship, Annex J lordship. This is the notice served upon me lordship by the inquiry officer who has seized my tractor lordship. What happened in this case lordship? This petitioner apprehended in a NDPS case under the Jammuguri police station lordship. Thereafter, his tractor also seized lordship, and that tractor also lordship seized lordship as the illegal acquired property lordship. This is the notice lordship, and thereafter lordship subsequently that seizing order of the inquiry officer that has been confirmed by the competent authority of the administration is only in foreign exchange manipulation forfeit property act lordship. First of all, I would like to draw the attention of the notice lordship, page number 31 lordship. Annex J lordship. May I read it, sir?
Yes.
Yes, lordship. In exercise of the power conferred upon me under section 68F read with 68E of the NDPS Act as amended, ASI UB Kabir Singh Lambo Office OC of Jammuguri do hereby freeze the properties in connection with the Jammuguri PS case number so and so as mentioned in the annexure subject to the confirmation of the competent authority, Commissioner of Custom House 15 Street, Strength Road, Calcutta. So you are hereby directed to appear, directed that the property hereby frozen sale be transferred or otherwise dealt with except with the prior to the permission of the undersigned or of the competent authority mentioned above. This is the notice served upon me, Lordship, and annexure K, page number 32. This is the property details of the annexure 33. Annexure 34, Lordship. This is order of the physics 34, last paragraph, Lordship. And thereafter, this order of the IO as confirmed by the competent authority, that is, your Lordship will find page number 35, annexure M, Lordship. In this case, Lordship, I have not given any opportunity to opportunity being heard, Lordship. That is why it is violation of the natural justice, Lordship. I would like to draw the attention to paragraphs of the confirmation of the competent authority, Lordship. That is, your Lordship will find page number 37, Lordship, para 6, Lordship. Page number 37. Got it, Lordship?
Yes.
May I read?
Yes.
Para 6, Lordship, page number 37. In the interest of the
It is under which provision?
Lordship,
It is under section
68E, Lordship. Your Lordship, this is confirmation order starts from the page number 35, Lordship.
there is no provision for appeal.
Yes, there is provision for appeal, Lordship. 68O, Lordship. But this confirmation competent authority is the appellate authority, Lordship, appellate tribunal, Lordship. So already they had their findings was that there was no illegality in the order passed by the IO, Lordship.
No, who is the competent authority?
Competent authority is, Lordship.
NDPS.
Yes. 68D, Lordship. D, Lordship.
68.
D, Lordship. This is competent authority.
So where is the appellate forum?
With 68O, Lordship.
Here.
And 68E is, Lordship, constitution of the appellate tribunal, Lordship.
68.
68E, Lordship.
E is identification. 68D is competent authority.
Yes, D is competent authority, Lordship. And thereafter, Lordship, constitution of the appellate tribunal, Lordship.
And where, under what section this order has been passed?
Order has been passed 68E, Lordship.
68F.
Yes, EF.
Mr. KL, you are for the NDPS?
Yes.
Where is the appellate tribunal? Under 68N
In the ministry, Lordship.
in the ministry. You serve him a copy.
Yes, Lordship.
We'll take up the matter at 2 p.m. Just I will.
Lordship.
I'll serve that knowledge.
2 p.m. So you can take back your.
Yes, that will.
I will be glad.
Please, Your Lordship. The matter is related to condonation of delay in filing the return.
Condonation of delay.
Delay. The Government of India has launched a scheme under section 115 BAA. Under this scheme, private limited companies of Indian origin
can pay a tax of at the rate of 22% plus surcharges instead of 30%. This scheme was applicable for the assessment year 2020-2021. But in the instant case, the petitioner has filed the return on 31st March instead of 15th March. So there is a delay of 16 days. Already on that year, several adjournments or several relaxations were given in filing the return. The petitioner failed all those occasions because he was held up in New Delhi and the establishment is in Guwahati. Because of COVID, he could not file it on time. There was a delay of 16 days. Later on, Government of India, Central Board of Directors has gone down through a general notification, has gone down all the delays in filing this Form 10 IC, which is required to avail the concession under Section 115BEE. That means to avail that benefit, the SSC has to file Form 10 IC, and that form has to be filed before the filing of the return or on the date of filing of the return. In the instant case, the return due date was 15th of March, and the petitioner has filed on 31st of March. So they have approached the competent authority to condone the delay. It is in Annexure 9.
Page number?
Page number 46. So they have applied. In this case, they did not get a reply, but in a similar case of similar sister company, the authority has replied. The item is item number 16 in today's list.
Item 16.
Item 16 of today's list.
They have replied. And
They have replied and they said that they have no power to condone the delay because the SSC has filed the return 16 days later, not on due date or 16 days after due date. Now that part can be condoned. CBDT has that power under Section 1192 that they can condone the delay on genuine grounds.
do you apply before the CPD?
No. Yes, CBDT can be applied. I want direction from this court that on the ground of genuine hardship, CBDT should consider my application.
You first
Yeah.
apply.
Sir-
Unless you apply, where is the question of issuing a direction that should be?
In a similar case, the High Court of Telangana has issued direction to the CBDT
Hmm.
considering the genuine hardship of the applicant.
Whether in that case,
Yeah.
the application was already filed?
Yes, no, he did not approach the CBDT. He directly came to the court. I have approached the CIT, not CBDT, CIT. CIT has said they don't have the power. So the court should acknowledge that in my case, it is a genuine hardship. So there
How
was,
do we know it is genuine or non-genuine? It is your submission, it is a genuine hardship.
yeah, genuine hardship. I have submitted medical document that I was under quarantine.
Maybe.
Okay, in a similar, Telangana case is exactly the same date, same order. They have also filed on 31st. They approached the,
Telangana High Court is not binding on us.
not binding. Similarly, it was
But we
decided
want to understand is why are you apprehending that why do you need a direction
because
when you have not even approached?
no, we have approached the CIT.
Maybe they don't have the power.
Yeah, no, they are saying that the condition mentioned in the circular, condition 1, that the return should be filed on the due date
Where is the circular?
in the another item number.
Page 42.
40. Yeah.
Number two, on consideration of the matter, number 3, on consideration of the matter with the view to avoid genuine hardship of the domestic companies in exercise of option of under section so and so, CBDT in exercise of powers conferred under section 1192B of the Act hereby direct that the delay in filing of Form 10 ICS per Rule 221AE of the rules for previous year relevant to assessment year 21-22 is condoned in cases where the following conditions are satisfied. Number 1, the return of the income for relevant assessment year has been filed on or before the due date specified under section 139(1) or 5. In my case, this has not been done. Number 2, the SSC company has opted for taxes under section 115B of the Act in the item E of the filing status in part A general of the form for return of ITR 6. This has been complied. And number 3, form number 10 IC is filed electronically on or before 31st March 2024. This has been extended. This has been complied. We have filed.
You did not comply, number 1.
Number 1. We have failed to comply number 1.
Yes, Mr.
My lord, the power to condone delay is with the, only with the, my lord, the board, my lord. And my lord, board, my lord, has from time to time has extended the date for filing returns, my lord. Initially, my lord, the period was up to 30th of November 2021. That was extended to, my lord, 15th of March to 2022. And they filed it, my lord, admittedly, my lord, on 31st of March 2022. So there was a delay. And power to condone the delay only with the, my lord, the board, my lord. So, my lord, the best possible way is he may approach the board, my lord, for condonation of delay. Because this circular has specifically said, my lord, he is entitled for filing the form 10 IC only if the following conditions are fulfilled. And condition number 1 was not fulfilled, my lord. So, my lord, the assessing authority has no power, my lord, to condone the delay, my lord. That was with the board.
Lordship, I want direction from this court that on ground of genuine hardship.
See, the court will issue a direction only when it appears to the court that the authority who's goes with the power has not exercised or has refused to exercise the power. You are at a stage where you have not even approached the authority. Then you want a direction. Has the CBDT said we not exercise their direction, their jurisdiction? Has the CBDT refused to entertain your petition?
No, CBDT has already condoned the delay. So that part has been looked at.
Right.
See, for CBDT by way of general notification, they have condoned the delay.
Correct.
Only that first part which has not been complied with, that CIT will be the appropriate authority to condone that part.
Show us from the provisions of the Act, Roots notification that there is a power.
No, that, let me read that order.
Page number?
May I read section 1192B, page number 9.
Page number 9.
Section 1192B of the Act reads it, the board may, if considered it desirable or expedient, so to avoiding genuine hardship in any case or class of cases, by general or special order, authorize any income tax authority, not being a joint commissioner appeals or commissioner appeals, to admit an application or claim for any exemption. That means they are giving power to the authorities, income tax authorities, accepting joint commissioner appeals or commissioner appeals for deduction, refund, or any other relief under this Act, after the expiry of the period specified by or under this Act for making such application or a claim, and deal with the same on merits in accordance with. That means the condonation has to be done by the commissioner. So if this honorable court admits my genuine hardship.
All right, Mr. Setia, you get your
Lot.
Mr. Setia represents all respondents.
My lord.
Petitioner is agreed by the fact that the returns as provided by the section 1192
1192B
has not been rejected the ground of delay of an account rapid notification dated 23 whereby the general notification was issued for condonation of delay under section 119B the income tax act providing of form 10 IC assessment year 2020 and account. Let me tell you, there was a delay in filing. It was rejected by the competent authority. However, referring to section 190B, it submits that CBD has the power to direct any income tax authority to admit any application or claim for any exemption, deduction, or any other reason after expiry of the period specified, taking into consideration the hardship faced by state system. Let the standing council income tax obtain the instruction to be listed after extra.
Courtship, in the interim, no courtship action may be taken to recover.
No, no, my lord, prima facie, my lord.
No, no.
In fact, my lord, only in item number 16, my lord, the order was passed by the, my lord, the adjudicating authority. In item number 9, my lord, no order.
Yeah.
As of now, it was passed.
No.
On apprehension, he has filed.
So similar facts are there.
In item 16.
16. They have replied.
The order was passed in item number 16 only.
Question of injury found and to be listed on 17th of July. 17 July.
17. Courtship, in item number 9, my name is not reflected in the council.
Names of all council be reflected.
And one mistake is there in the post title of item number 62. One spelling mistake.
You do it on the next day. Reminder.
Obliged.
May I please, Lordship? My lord, petitioner is the wife of the deceased, and her husband has been killed by the private respondents. The FIR, Lordship, may kindly see page 13. Here, my lord, petitioner husband Umar Farooq was killed by the private respondents, and the area where the murder took place falls within Boribazar outpost under Mikirbeta police station. Now the petitioner filed an FIR before Boribazar outpost, but police refused to accept the FIR and said that this is the case of accident. Then, my lord, invoking section 154 within bracket 3 of the CRPC, I approached the SP. Then SP sent the petition, that is the FIR, to the in-charge outpost Boribazar for registering a case and investigation. Thereafter, my lord, the police has arrested only 3 persons and they have been sought no remand. So whatever they have, casually they have been arrested only 3 persons out of 6, and one murder person, Rahul Amin, who is named in FIR, was called in police station. He sits police station, but police does not arrest him. He has been let out without taking any action. Now, this is a serious case, my lord. My grievance I raised before the SP again, that though the case has been registered, but police is taking no action, but police says it is a case of accident. My lord, we have not annexed the postmortem report, but unofficially we have collected it. If your lordship permits me, then I may say the opinion of doctor. Doctor says that, my lord, yes, that may lordship may kindly see it.
Yes, the response.
So our prayer is this, my lord, the high-level investigation either by CBI or CID. Local police will know because they are very influential person and they are sitting 500 meters. Their house is within 500-meter range.
Let the government advocate obtain the instruction. Yeah. Find out what steps have been taken towards investigation. But, oh, FIR thing or investigating or pursuing the matter in high court. Private response 6 to 11. 6 to 11 are the suspected persons.
Suspected persons, they are named in FIR. 3 have been arrested, others 3 they have not taken.
The FIR. Spite of that, the investigation has required people by the investigating authority within the which police outpost?
Bori Bazar,
Bori Bazar.
under Mikiribeta police station.
And accordingly, FIR was brought. The
One small prayer. Here police is saying that take rupees 2 lakhs and withdraw the case. This is the role of the police.
FIR refused to be registered by the authority. However, subsequently the agent forwarded the SP of the district the FIR registered. Since the failure to actively proceed with the investigation as required. To hand over the investigation CBI, the CID for deep investigation in the matter, taking it to the government FIR not stated permit or extra publicity permit in the court. Matter be listed again. After 2 weeks. You can take it back.
A date will be fixed.
26
of life. 11.
That series.
Series.
Series matter. Give the numbers, we'll take it up.
I've already given number to the principal.
Call them.
My lord.
Please, your lord. But this application has been filed. Is it, my lord, inaction of the police administration, my lord? Whatever your lordship, my lord, I am a owner of a pawn shop situated at, my lord, Adabari. In the month of March, my lord, one goon has entered into my shop and forcefully closed the doors and put in a lock, my lord. Thereafter, I filed a FIR at page 14 Annexure D, my lord. That was not registered. Again, my lord, I filed an Annexure E page 24. That FIR was also not registered, my lord. Your lordship will find page 14, my lord, annexure D, my lord.
There is an online portal.
My lord. My lord, that I have, my lord, another application I have filed 144 and another representation to the police commissioner for my lord, some justice for the petitioner, my lord. That was also not done, my lord. Police is
Where is your
speaking about
FIR?
the matter. My lord, page 23 is the vernacular, my lord, page D, annexure D. It will be clear from the vernacular, my lord.
This has not been registered.
Not this time, my lord.
Then why don't you file it before the SP? Under 150.
My lord, thereafter, my lord, I have filed in proceeding under section 144, my lord. That your lordship will find at page 26, my lord. A report was called for from the DCP West, my lord. That report also not furnished, my lord. So if my lord, my learned friend will apprise this court whether any action has been taken or not, my lord. Otherwise, my lord, the petitioner is suffering.
He
my lord.
can apply under section 166.
That I will apply, my lord.
But
No,
this
before
FIR is
SP.
not registered. Why is it not registered?
That for that he may file application before SP lordship.
Why do you want him to file? Why the FIR is not registered? There are judgments of the Supreme Court.
The lordship will find an annexure J, my lord.
FIR, it has to be registered. Or give reasons why it is not required to be registered. You get the instructions here. Because it can be made to run from one quarter to another.
Well,
if the authority feels that there is no case made out, let them say, you don't file it, send him to SP, SP will send him back to the station. The report is called for, not done. Where will they go?
Up to commissioner, I have already run,
Where
my
will
lord.
they go? Somebody competent in the authority must come up and say that it is not required to be registered or there is no case or inquiry made out. Then he may have grievances for any other authority. Third current Part B, 4. Steps of response 5. Would you like to take Dusty?
No, my lord, he will not accept, my lord.
It is important to status of any investigation that we have been carried out. But when FIR 13 I think even the FIR has not been then the report has been reprising is therefore the government get a
My lord, may pay small thing, my lord. The pendency of the writ petition may not be barred to open the log on the premises by the police administration, my lord.
Where is the provision to open a lock? Who has locked it?
This, my lord, respondent number 7, my lord, forcefully, my lord. He is taking the law in hand, my lord.
You take recourse to the remedies available under law.
That
Why do you want a news statement from the court? News order from the court?
My lord, that observation will suffice.
That observation will create a lot of problem. We are not going to give you. You are here before the court alleging that your FIR has not been registered.
My lord.
We are addressing that.
My lord.
If the whole purpose is to get the lock open, then we are dismissing your petition.
My lord. Obliged.
This application filed under section 11(6) for arbitration act for appointment of arbitrator. for adjudication of dispute.
Where is the agreement?
Agreement is at page 18. Annex 40, Your Lordship.
Is 18. Arbitration.
Arbitration clause is at page 61. Your Lordship. 76 clause. May I read?
Yes.
Any dispute, controversy, or claims arising out of or relating to this agreement or the breach, termination, or invalidity thereof shall be settled through following mechanism. Firstly, the aggrieved party shall write a letter to the other party dealing its grievances and calling upon the other party to amicably resolve the dispute by convening a joint meeting. Accordingly, the parties, as per their convenience, shall jointly convene the said meetings, wherein minutes of the said meetings shall be prepared and countersigned by all the parties. It is mandatory to prepare minutes of meeting.
Litigation mediation is over.
No, no pre-litigation mediation have been convened, Your Lordship. The mechanism prescribed herein is that mechanism pre-litigation mediation with Guwahati Honorable High Court, Your Lordship. However, Your Lordship, the High Court, this Honorable High Court does not enjoy any original jurisdiction with regard to contractual civil disputes, Your Lordship.
We are referring to the agreement which you have entered.
Okay.
Agreement says that there has to be pre-litigation mediation.
Yes, Lordship. But
mediation.
Yes.
It's a question of original.
Yes, Lordship. But Lordship, mediation cell of the High Court only facilitate those mediation cases which were filed before the Honorable High Court, Your Lordship, and then referred to mediation cell only.
So we'll refer it to mediation now. You want? Yes, Mr. Gould.
There is also lawsuit. My lord may kindly page lawsuit the last page lawsuit. Last page lawsuit, last paragraph lawsuit. They are called for joint meeting lawsuit, but the petitions is silent about the lawsuit outcome of the death.
Meeting was held, Your Lordship, but no amicable resolution could be arrived at between the parties.
But see, your arbitration, the very purpose of going for arbitration is derived from the arbitration clause. That clause itself contains that you try for a
Pre-litigation, Your Lordship.
only if it fails. Very categorical.
Yes, Lord.
Only upon failure.
Since the Honorable High Court has no original jurisdiction, because they have not filed any case in respect of this.
You parties agree and go for mediation. If it is not there, you file an application, we refer it to mediation. Or we can refer this itself to mediation. Mr. Gupta. What do you say?
Mediation part lawsuit. If lawsuit is right,
If there is a failure of the mediation,
lawsuit.
then it goes for arbitration.
Lawsuit.
Now, under the new amended rule,
Lawsuit.
amended section,
Lawsuit.
you can't appoint the sole arbitrator. It has to, they'll have to come to the
As
court.
per 15 laws. 12.5.
12.5.
12.
So in any case, you'll have to come to the court.
12.5, yes, because it's preferred a petition before his honorable court. Then lawsuit 12.5 automatically comes.
Right.
Then the jurisdiction is before lawsuit.
Prior to 12.5, there is a provision for.
And even lawsuit that particular notice itself not demand for arbitration lawsuit.
Where is that?
Page 66 lawsuit. It's for notice for resolution of contractual dispute lawsuit.
This is
Notice was for raising dispute, not referring the arbitration.
They have not come for arbitration also lawsuit.
So this is what is to be settled
Before the
mediation.
lordship, it is not for arbitration lawsuit. It is not for arbitration.
Prior to seeking arbitration, you must issue
Lordship, otherwise, Lordship, as per the law, Lordship, this petition is Lordship premature because he is not preferred the petitions for arbitration, Lordship.
What to do, Mr.
Lordship, let the notice may be issued, then
Notice on what?
the response number 1.
Your prayer is for appointment of the sole arbitrator.
Yes.
So prior to sole arbitration, there are 2 steps. Besides the notice being issued, which you have not issued, the agreement itself says go for pre-litigation.
Even Lordship, there is no demand for arbitration
There has
also.
to be a
Lordship.
failure of the
Lordship.
mediation. And then an notice to appoint an arbitrator. Assuming in view of 12.5, we say that notice is not required.
Yes.
But at least the mediation part will have to comply with the part of the agreement. It's an agreed term between both parties.
Even Lordship, 12.5 also there should be a demand, Lordship. There should be a demand. We are not able to appoint the arbitrator on its own, Lordship. Otherwise, there should be a demand, Lordship. That demand is also absent, Lordship.
Yes. You withdraw this and file.
Lordship, this court may refer the parties to mediation. Mediation, because your Lordship, if any failure of the pre-litigation mediation mechanism with Guwahati High Court mediation case,
And then he have to prefer an appropriate petition. Otherwise, the arbitration.
Praying for appointment of the court. Disputes arising the parties arising out of the agreement number 20. Petitioner to awarded the contract of work has been completed, not
work has been completed.
Submitted the contract. However, respect to the work cycle and all the parties that have court appointment of an arbitrator. Mr. Gogoi has no notice as mandated under the Arbitration Act has been issued. An arbitrator therefore, it is a premature petition seeking appointment of an arbitrator. The petitioner did not approach the authority demanding matter be handled to us. Upon there are see that as per the it's clause 76 the agreement. The agreed between the parties that there shall be an attempt to mutually resolve it. And in the event there is unable to reach any settlement, the aggrieved party shall mandatorily resort pre-litigation mediation mechanism with the Guwahati High Court mediation cell. So, upon failure of the mediation mechanism with the Guwahati High Court mediation cell, that the aggrieved party will resort for appointment. There is no dispute of the bar that in this stage the petitioner has not called upon the respondent seeking to resolve the dispute to a pre-litigation mediation. According to the registry, the matter is referred to pre-litigation mediation. The procedure within the Guwahati High Court mediation center. High Court mediation committee will engagement of competent mediator or the parties to resolve the dispute. Let the matter be listed again after 6 months. Extra copy will be needed. Required to serve in the court after. The petitioner will approach the registry, seek remediation, settlement in terms of clause 76.
76.1 loss.
Huh?
76.1 loss.
76.1 along with the copy, certified copy.
Only soft copy দিব হ্যাঁ hard copy না।
May I bring the lordship, madam? My case is just like earlier one, madam. Here in this case, madam, the terms and conditions of the agreement, madam, and the other condition, all this pre-arbitration stage, my lord, the moral is gone, my lord. Page 7, paragraph number 7, my lord. My statement, I'll show the document, my lord. Earlier, I'm not reading, my lord, just the states that according to the failure on the part of the parties to settle their issues, the dispute resolution meeting with the contact management committee. That is the committee, my lord, where it has to be done finally, my lord. Held on 1/2/2024 at the office of the General Manager of Airport Authority, Regional Headquarters, Northeast.
Where is the agreement?
Yes. Yes. Agreement, my lord. Agreement page 23, my lord. And relevant part, my lord, page 23, my lord. And just see. And relevant part, your lordship will find page 26. Page 26, article 4(1).
23.
No, my lord, article 4, my lord. Page 26. It is specifically agreed between the parties that all the differences dispute arising out of the agreement of touching the subject matter of the agreement shall be decided by a process settlement and an arbitration as specified in clause 9, particular condition of contract. I'll take to your lordship there. ATC of the contract as applicable. Arbitration proceedings shall be conducted in accordance with the provision of the Arbitration and Constitution Act 1996 as amended from time to time, and Guwahati High Court alone shall have the exclusive jurisdiction over the same. Now, my lord, the terms and condition, my lord, particular page 43. What is to be done before going to that, man? Yes, page 43, my lord. Here is the page 43 and relevant portion. You start page 55, my lord. Settlement of dispute. One page, my lord. Settlement of dispute, my lord. Here, how it is to be, that is the last paragraph, my lord. If the contract management committee dispute resolution, it fails and give its decision within aforesaid period, any party dissatisfied with the decision of the contract management or expire of the time limit given above, either party may within 30 days of the receipt of the central management committee dispute judicial give notice of the result. Here in this case, my lord, minute of the meeting, nothing has been served to me, my lord, from February, my lord. So we attended and raised our grievance. Next page, my lord, page 56, my lord. Only one line I will read, my lord. The second paragraph, the regional executive director shall in such case appoint the sole arbitrator or one of the three arbitrators as the case may be within 30 days. My lord, he is to, they have to make the call fast, my lord. Then only we can proceed, my lord. The respondent is to appoint the party.
Who's for the respondent?
My lord, that is airport authority.
My lord, I appear on behalf of the respondent numbers 225.
Get your instruction.
Yes, madam. Yes, my lord, it used to be soft matter, that is it.
You to respondent number 5.
It's after
All right, deep privilege.
Please, Your Lordship. The respondent were directed to get instruction by the order dictated. And so, Your Lordship. We have filed a review, it is at annexure 9, page 34.
Yeah, who's for forest? Where is the forest standing council? Yes, Mr. Kuku, anything?
To be honest enough, my lord, this appeal, my lord, the conservator changed, my lord. Now they are unable to take the file. My lord, I have to undertake that within 15 days, my lord, will be passing this orders. Let it be listed after 20 or 15 days, my lord. They've lost the file, my lord. I have contacted DFO, DFO had forwarded, my lord. I'll to have it.
Raise for further time. Let it be in July.
Yes, yes.
19th July.
My lord.
Deeply obliged.
This is other matter, my lord. Other family members got the other, but his other was enrolled, my lord. Biometrics taken 11/6/2019. There is no dispute as to his, my lord, NRC. Already his name is there within the NRC, my lord. And they say for the NRC, there was some dispute, and that is why they are keeping this matter holding. So there cannot be any question, page 24.
CGC, who's for CGC?
I am appearing for CGC, Lordship. Affidavit is ready, Lordship, and it is sent for vetting. Within 1 week, I will file affidavit. Kindly accommodate 1 week time, Lordship.
We get that for the petitioner, MSS Borwa. Submit that.
Yes, Lord.
With the matter.
17th July.
25 June.
So let it be in July.
Yes,
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 yes.
17th.
17th.
After the opening on 17th.
Obliged.
Obliged.
May I please, Your Lordship. First of all, Your Lordship, today is the first day, but it may be listed on motion column, but wrongly listed in admission column. And the case of the petitioner is that, Your Lordship, one Abhimanyu Kumar Singh had expired due to accident, and thereafter petitioner submit an application before the respondent number 3. Notice me.
Ms. Borwa appears for respondent 1. And do you represent 2 or 3?
Your Lordship, I'm appearing on behalf of respondent number 2, Assam State Legal.
What about 3?
2 and 3.
1 and 4.
2 and 3.
I am not appearing for.
Appears for respondent. Steps of respondent.
Lordship, she appearing respondent number 2 and 3.
No, it says
3 also.
3 also.
3 also.
3 also.
Another cases, they are appearing both.
Is confused. 2 or 3
Your Lordship, 2. I was.
steps of respondent.
Lordship, it will be better to pass for timing. Ma'am will become and he will be.
If they accept you serve copies, we'll record it.
Lordship.
Three steps of respondent. I raised it 4 things. I said after 4.
No, deep.
My lords,
Yes.
I am filing this petition, my lords, to protect my right to life, my lords, right to equal protection of laws.
My lord's private respondent number 6 is my business partner. And we have some differences, dispute, I'm not on that, my lords. The issue is that he, by putting me into the fear of injury, by show of the criminal force, he wants to settle everything without taking due process of the law, legal recourse, my lords. My lords, he even forced me to sign some sale deeds also, my lords. Forcibly got executed some papers regarding the property. I want to take legal recourse, my lords, for that. But the issue is that he by putting me to the fear of injury, my lord, I have filed complaint with the police also. Police is not taking any action. So I two remedy, my lords, I'm intending by the state petition, my lords. Number one, direction to the state authorities, my lords, to ensure my safety and security, and direction to the police, my lords, to register the case. This is the.
Where do you reside?
My lords, I reside in Kamrup, my lords. I am native of Gazipur district of Uttar Pradesh.
But presently you reside in Kamrup.
Kamrup is there, my lords. Office is there. Office is there. But I also have my home in Delhi, my lords. So safety and security of the state is bound to ensure, my lords, so that I can pursue my remedies here, the arbitration matters and all that, everything I have to do, my lords. But once safety and security is ensured by the state, he is liaising with the local administration of the police, my lords, and possibly for that reason, I can't say anything, my lords. No action is being taken by the police.
Yes.
Instruction required, yes, sir.
And by inaction or dressing spite of facing threat. Where are the FIRs you find?
To the police administration of the state, my lords, and the SHO concerned is my complaint is at page 68, my lords. SHO Gorchuk, my lords, Guwahati.
Petitioner by has lodged an FIR on 9 April 2020 before the SHO Gorchuk station. Claims were filed. And however, in spite of that, is investigation. So, here those related investigation. Other state functionary by ventilated by as stated by filing the FIR concerned the government court of state investigation that status of any investigation if initiated by investigating FIR finished. Extra copies be furnished government advocate within a period of this week. With the matter listed here on
24th of
June.
Please, madam. Hello. Some sort of interim protection from the state, my lords, may be ensured.
Let us find out. 24th.
Please, madam. Please. Hello. My appearance may be marked, my lords.
Yes. Your name?
Ajay Kumar Rai.
Mr. A.K. Rai.
Please, madam. Hello.
Your Lordship. Lordship, firstly, I would like to mention that the matter has been wrongly listed in the admission column. This is the fresh filing, so it has to be come up in the motion column. And the matter of the fact is that The writ petition is filed by the petitioner for conducting a fair and judicious, not judicious, fair investigations by the CID department regarding the death mystery of his deceased daughter.
All right, heard, counsel for party. Says for government in the case of government. For part of the report. Steps of respondent by registered state. And it reports to be undertaken within the it's the responsibility. Part four of the department. Paper of the this after.
Apply, sir.
Made legal. Lordship, here the petitioners has approached the concerned authority for allotment of a plot of land, Lordship. And after taking into consideration, the Land and Advisory Committee needs a no objection from the respondent number 2 and 3 because the land is a PWD reserve land. Subdivisional Land Advisory Committee, Flipsagar Lordship, they need a NOC from the PWD concerned period since the land is a PWD reserve land.
Yes. Yes.
Receive instruction.
Extra copies may not. The matter be still after 2 weeks. Yeah, the beta for
May I say this, Your Lordship? In this case, Lordship, we have received instruction, Lordship. Let me tell you. Tara. No, I can't. No. They have allotted a budget for an amount of rupees 1,30,000, Lordship. For 13 people, Lordship. And they have written it, their communication is annexed, Lordship, for Deputy Commissioner Kokrajar. They have written for a fresh proposal, Lordship. As per our record, some payment has been made, Lordship, and that record is not with the Revenue Department, Lordship.
that reporting.
Not available with Revenue Department, Lordship.
Then how to pay?
That's the Lordship. This budget has been allotted for 13 people, and some
This is at the approval stage.
Lordship.
Sanction
Sanction authorities, disbursing authorities, Deputy Commissioner, Lordship.
whether sanction is drafted.
Lordship. Lordship. Lordship, according to the communication, Lordship, budget may be released immediately at this end, Lordship. This is the sanction, Lordship. Lordship may peruse the communication, Lordship. In this regards, accordingly, a letter by so-and-so, letter dated 29/5/2024, has been sent to DC concerned requesting him to provide legible copies so that budget may be released immediately at this end, Lordship. We have released 1,30,000, Lordship, budget.
Yes. Give him a copy.
Lordship.
Yes, Mr. Doctor.
Lordship may keep this as pending,
No
Lordship.
communication has been issued by me as of now.
You did not get.
Yes.
You are asking for money.
Yes.
They give you, you get.
Yes.
Why are you worried about communication?
If communication then I can be acquainted about the facts, my lord.
This communication is only deputy commissioner. How can I give you?
Some process is required to be undertaken. Once
Yes.
it's undertaken, whatever amount is paid.
Yes.
Budget has got to be earmarked.
Yeah.
That's the right. Yeah. Getting bored.
And for respondent number 1, Lord.
Even for me that budget expenditure 13 number that has to be regard communication letter by number 9 dated 29/5 that the DC concerned, namely DC Koprajar.
Koprajar.
By immediate. There are
Section number 2.
anything public?
Yes, no, no, my lord.
Public that he has in the executive department. Like
After vacation.
like
Yes.
19
Deep problem. Lordship, may keep my communication as kept upright. Deep problem.
Please, Lordship. Lordship, Dr. Saraf is next in court number 27 in a partnered matter, Lordship. And the matter be taken up after sometime or at 2 p.m.
2 p.m. 2 p.m.
Like that.
In this case, my lord, only respondent number 6, my lord, block development officer, my lord, filed affidavit stating that, my lord, the commissioner of the PNRD cancelled the schemes, my lord. And due to that reason, my lord, the petitioner has not given job, my lord. Matter pertains to, my lord, the petitioners are the job card holder under Kumulipura Gaon Panchayat, my lord. In last 3 financial years, he has not provided, my lord, job, my lord,
less than 100 days, and no unemployment allowance has been paid, therefore violates the MDNRA Act, and Section 3 of the MDNRA Act clearly stated minimum 100 days job provided. And otherwise, Section 7 also provides unemployment dues.
Yes, who are required to file affidavit?
Respondent number 3, because the respondent number 6 stated that the cancel the scheme,
Respondent 3,
Commissioner PNRD department.
PNRD, who's appearing for PNRD?
Standing counsel.
Please inform standing counsel,
Look.
PNRD.
Look.
Alternate counsel for the party. Who has filed affidavit?
Respondent number 6, block development officer, Borpeta.
Block development is under PNRD only.
PNRD,
Then why do you say PNRD has to file another?
He stated on his official paper stated that schemes are cancelled by the commissioner. Due to that reason, he has not provided jobs.
An affidavit has been filed on behalf of the PTO or beta block, to which the reply has been filed. However, the statement the environment that the affidavit scheme has been cancelled by the commissioner. The government, some PNRD. You want to file an affidavit? Get your instruction for the study council PNRD are permitted to complete their instructions and file necessary affidavit. Hence, N. Bora here for PNRD department. Mr. N. Goswami for respondent 4. Your name?
P. Borua from respondent number 1.
P. Borua.
Oblige. 39 also same.
39 order, same order.
Same.
My senior is actually out of station at Aizol bench.
Senior is?
Out of station at Aizol bench.
You submitted that out of station. Therefore, the matter be state of the mother.
On the next date, Lordship may indicate that they have reported the claim, not on ground of fraud, but misstatement. Whether they have refunded back that amount,
we don't know.
It would not be maintainable otherwise.
Raise it on the next day.
Absolutely. Date may not be fixed.
Let it be in July. July.
After vacation.
After vacation. Let it be listed on 19 July.
Right.
Anything?
That's it. The last day they were directed to file an affidavit, Lordship.
Affidavit.
Affidavit. Bringing on records the agreement copy of the contract. Lordship.
There is no order. And if it's
Obliged.
should be listed after what on a date. May to be listed after what?
Obliged.
Yes.
Also, my senior is coming also.
47. Fast.
That is against the cancellation of GST registration.
But here, my instruction is awaited.
Action awaited.
Yes, sir. This is a separate issue, not related to the other connected case.
Are those covered by the orders passed by the Honorable Court? Court has given liberty.
Let him opt in. Let him opt in.
Short date may be given.
After vacation, no.
Payment for the tax of very good.
But the time. Over to the but the time. If the matter is listed after
2 weeks now.
2 weeks.
2 weeks.
Much of it.
2 weeks will look at reminder.
Yes. Where is that 69?
69 Lordship. Here we have filed our affidavit that is placed on the record.
69.
16.
Yes. What do you say? What is your stand in the affidavit?
Lordship, paragraph 3, page 63.
Where is the section? Let us see the section. Yes.
168.
168A.
Capital A.
Yeah, please read.
Power of government to extend time limit in special circumstances. 1. Notwithstanding anything contained in this act, the government may, on the recommendation of the council, by notification, extend the time limit specified in or prescribed or notified under this act in respect of actions which cannot be completed or complied with due to force majeure. 2. The power to issue notification under subsection 1 shall include the power to give retrospective effect to such notification from the date not earlier than the date of commencement of this act. Explanation. For the purpose of this section, the expression force majeure means a case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any of the provision of this act.
By which notification you have extended?
Lordship, there are two notifications. Lordship, one is 9 of 2023.
Page number
41, my lord. Authorized citizen.
Page 41. Notification number 9 of 2023, dated 31st March 2023. Merit.
Yes.
In exercise of power conferred under Section 168A of the Central Goods and Service Tax Act 2017, herein referred to the Act, we read with Section 20 of the Integrated Goods Service Tax and Section 21 of the Union Territory Goods and Service Tax Act 2017, and partial modification of the notification of the Government of India, Ministry of Finance, Department of Revenue number 35/2020, Central Tax, dated so and so, published in the Gazette of India, Extraordinary Part 2, Section 3, Subsection 1, byte number so and so, dated 3rd April 2020 and 14 of 2021, Central Tax Act, dated 1st May 2021, published in the Official Gazette, Extraordinary Part 2, Section 3, Subsection 1, byte number so and so, byte so and so, published in the Gazette of India, Extraordinary Part 2, Section 3, Subsection 1, byte number so and so, dated 5th July 2022, Government, on the recommendation of the Council, hereby extend the time limit specified under subsection 10 of Section 73 for issuance of order under subsection 9 of Section 73 of the said Act for recovery of tax not paid or short paid or input tax credited wrongly availed or utilized relating to period as specified below, namely for the financial year 2017-18 up to 31st day of December 2023, for the financial year 2018-19 up to 31st day of March 2024, 3 for the financial year 1920 up to 30th day of June 2024.
What is the limitation provided under
73, 9 and 10 laws?
So 3 years. So 2017 will expire on 31st March 2020.
Lots. That has been extended for 17-18. It was extended up to 31st December 2023. Then 18-19 up to 31st March 2024. Then 1920 up to 31st day of June 2024. Subsequently, it was also extended. Next page, page 42. And lots of recently, two high courts, this notification has been challenged, but that has been upheld by the Allahabad High Court as well as the Kerala High Court. Lots well providing with hard copies.
Yes. What
My
is
lord,
the
this is the second extension, my lord. First extension was granted in 2022, my lord. There was a meeting, 47th meeting, my lord.
no, what is your plan?
My lord, first,
In respect of this 168A, there is a power under the statute.
My lord.
They can extend it.
Yes, my lord. on happening of certain events, my lord.
Yeah. What is that event?
My lord,
According to you,
no,
it does not fall under the parameters of 168.
my lord, on the date of issuance of notification, my lord, there was no pandemic, my lord. And considering the pandemic in 2022, already they have extended, my lord. February 22, they have extended till, my lord, 30th September, my lord. Thereafter, again in 2023, my lord, they extended till 31st of December. Then again in December 2023, they extended up to 30th of April, my lord. Now, whenever they feel, my lord, they are not able to complete, they take a ground of pandemic and they extend it, my lord. If your lordship will see that agenda and the, my lord, minutes, my lord, lordship will see copy and paste. And my lord, moreover, my lord, there is one more point involved here is that notification 56, my lord. For notification 56, there is no recommendation. It is a prerequisite, my lord, for issuance of notification, my lord.
Where is notification?
56, page 42, my lord. Though it is in claim the notification, there is a recommendation, my lord, from the affidavit filed by the department, my lord.
Recommendation by
GST council is required, my lord. From the affidavit, it appears, my lord, there was no recommendation, my lord. There was some GST committee who has made some recommendations, not a GST council. And my lord, we'll see there was a series of meetings held, my lord, by the GST council. It was, my lord, held on 18 to 23, my lord, whereby, my lord, notification 9 was issued. Then 11/7/23, 50th meeting was held. Then 2nd August 23, 51st meeting was held. Then 7/10/23, 52nd meeting was held. In those meetings, there was no recommendation was made, my lord, for extension, my lord. Now, my these things I have to bring on record by way of affidavit and reply, my lord. So, I am praying for some time, my lord, to file my reply so that I can bring those things on record, my lord. And suo motu extension, Supreme Court granted in 2022, my lord. As per my Supreme Court's order, my lord, there was 90 days. It appears, my lord, for common people, there is 90 days. For the department, there is unlimited time. Whenever they feel they are not able to do it, they extend it. If lordship may peruse the suo motu order of the apex court extension order, my lord, lordship will see, my lord, in February 22, my lord, they have the apex court granted 90 days time, my lord, for all the other SSCs, my lord. But for department, my lord, and in 22 also, my department, they have issued notification extending the time limit, my lord. Now, my lord, whenever at the last moment, whenever they see, my lord, they are not able to do it, they extend it, my lord.
the basis of that.
Because first of all, there is no recommendation for 56, my lord. There has to be a recommendation of 56, my lord.
So what provision?
Section 168 itself says, my lord.
On the recommendation.
On the recommendation, my lord.
What do you say, Mr. Kyal?
Which is there. I have sick leave of this to produce all the my notes before a lordship at the time of final hearing.
Now, lordship will this affidavit speaks about only 49th meeting, my lord. Thereafter, 3 meetings were held, but no recommendation was there, my lord.
No, but where is it stated in your petition?
But that's why I have to come with a reply because they have said notification says recommendation. Affidavit silent about recommendation. Now, my lord, recommendation has to be there, my lord. Therefore, I need to bring on record, my lord, by counting this affidavit, my lord, saying that there were other events where there was no recommendation, my lord.
Is this a ground that you have pleaded in your writ petition in the first place?
In some of the cases, I have pleaded ground, not in this case, but there are a series of cases, my lord, where I have taken the ground, my lord. And my lord, it is a question of law, my lord, because if there is the requirement is not fulfilled, my lord, then my lord, otherwise also this will not be stand in the eye of law, my lord. Supposing, my lord, in one of the petition I have not taken, but in other petition I have taken grounds, my lord. In that petition, lordship find.
Right. But say that they have not recommended.
Yes, my lord. That's why I bring because they are also silent about this thing, my lord, in the affidavit, my lord.
They are silent. There.
No, my lord, lordship will see, my lord.
As per the notification itself.
No, my lord, but in the affidavit, what they have said, my lord.
Paragraph 3.9, page 68. Three point nine. that in view of the above, it is evident that the notification number 9 of 23 dated so and so and notification 56 of 23 have been issued lawfully due to difficulty in implementation of the provision of the GST Act of the scrutiny, assessment, and audit work due to COVID-19 pandemic and subsequent issuance of demand notice and orders. The said notification have been issued under statutory power covered under Section 168A of CGST Act on account of force majeure, which includes an pandemic. It is again highlighted that as per the explanation of Section 68A CGST Act, force majeure includes pandemic and was pandemic affecting implementation of the provision of CGST Act for scrutiny, assessment, and audit work. And 3.11 also. In addition to it is indicated that all policy decisions with respect to CGST Act are taken only with the recommendation of CGST Council, a constitutional body established under Section 279 of the Constitution of India, which is entrusted to make recommendation to the Union of India and the state on or other matter related to GST.
Let's say actually what is the recommendation, my lord? In which meeting they have recommended, my lord? Council has recommended, my lord.
Yes. Other council. So in your matter, Mr. Saraf, they have already appeared.
Lordship.
For the sake of formality, we can issue a notice. That's not difficult.
Lordship.
But he says that only one affidavit will suffice. Probably.
If he says so, if he relies on so, I have been furnished a copy of the affidavit in the evening yesterday. Okay? So I need to furnish a reply. And
There is some part. The repetition are the extension of signification. I are the convert totally dates of the notification.
31/3/2023 and 28/12/2020.
44 and 42, my lord.
41 and 40. Dated with limitation presented by CBI and Court of Indirect Tax. This notification are primary that the not available following right. So, approval of no recommendation. There is right. Yeah. Yeah. That is quite an academic. Pandemic can become at least only the post curriculum and that yeah, the big like nine that statement. Copies of this affidavit.
All it
are
one.
all the copies. Hard copy.
Hard copy I have already submitted to all the, already submitted.
And the
VIVEK, 4 weeks. Lordship, just to point out to your registry, 2017-18 extension, 2018-19 extension, 2 batch of petition. Central GST cases, state GST cases, again 2 batch of petition. So these have to be distinguished while our Lordship deals with it. Because there is no notification of extension by the state authority. Lordship. And again, and when your Lordship deals with whether it was affecting the implementation of the provisions of the Act, 17-18 facts might be different, Lordship. 18-19 again facts will be different for considering the timelines. Lordship.
Essentially, it's a question of extension of the limitation. That's the core issue in all the writ petitions.
Item number 11, 14, 15, 17.
I have already given the
fresh matters.
I have given the list.
So motion matters, Lordship, it might be considered to be
Interim for protection, my lord. In all other matters, protections are there, my lord.
motion matters only, Lordship.
Motion matters.
Only all admission.
No, these are come for first time, my lord.
For first
7,
time, some
7,
matters have
11,
come up before you.
14, 15, 17 are,
Item numbers.
my lord, 7, 11, 14, 15, 17, 18, 19, 20, 21, and 22, my lord. List, I will provide list, my lord.
You provide the list. Then we'll issue notice and there'll be no court effect.
Lordship. I shall oblige, Lordship.
See, I apologize, let's say I was.
Yes.
Lordship, I am a patta holder of a particular land, which was bought by me by a seal deed in 1954. Then, Lordship, what has happened is that I signed an agreement with a person who took the land on lease, and he wanted to set up one petrol pump there, and a company has allotted a petrol pump. Now, all the NOCs that is required as per the mandates, I have got all the NOCs, but like as far as the forest NOC is concerned, forest has refused to give me the that NOC, saying that it's a forest land. As far as Lordship, that one affidavit has been filed by the revenue department, and revenue department has specifically clearly stated that it's a patta land. Now, forest department has not come up with their affidavit, Lordship. An affidavit has to be filed by the forest department because otherwise my land is being stuck. The person has invested money, and like company is pressurizing on me that I should get the clearance as soon as possible. Forest department is not doing anything. In fact, Lordship, a joint survey was done, and in the survey it was found that it was a patta land. Now they are coming with a plea that it was under the forest land.
So what does the affidavit say?
Affidavit of the revenue department, Lordship, that has been filed. Revenue department has specifically stated in paragraph 4, Lordship. I'll just read out that as per the land records available in the office of Rangjuli Revenue Circle, the petitioner is recorded pattadar of Dag number so and so of revenue village so and so. The Dag encompasses an area of land 3 acres so and so. The deponent says that mutation case number so was passed on 18/5/2017 in favor of the petitioner in place of his deceased father, late Paresh Chandra Roy. So land was bought a long time back in 50s. Then Lordship, it has come to me by inheritance. There was never any dispute about this land being a forest land or something like that. Deputy collector, then highways authorities, each and everyone, Lordship, they have I need to take the NOCs. They have cleared it.
Only the forest department is saying that like, this is under the forest land, and they are not coming up with the affidavit. My land is stuck for last 1.5 years.
Yes, the forest. Have you made forest the party?
Yes, Lordship. The impugn orders are against the forest department.
Where is the forest department?
Last time they were there, they said they will submit the instructions on the last occasion.
Forest.
In fact, my lord, the page 80 for the NOC, my lord, has been given by the Deputy Commissioner, my lord. After my joint verification by the Range Forest Officer, my lord. I am
All analysis have been given.
We'll just wait for a while.
Yes, ma'am.
Let the name be reflected.
Lords.
Forest item.
My lord, last occasion, the lordships had the matter, and my learned friend in the PhD side, my lord, they tried to place the judgment of my lord Bhupender, but that is not covering my case, my lord. And our case.
Who is your counterpart?
Lordship?
Who is the of the council?
Oh, PhD, my lord, PhD department.
Who is represented?
That
Mr. Water.
Mr. Water was there.
PhD. Reflected. Let him come. Let him come. Forest.
All
Good for the petitioner. Appears the rest of
I'm sorry, I was on legs and 27. However, we have received our instructions. We'll be filing an affidavit, my lord, and the land claimed to be by the petitioners are forest lands, as per our instruction notification.
But you executed some easily, no.
Yes, I have executed lease deed. I have executed lease deed. BPCL has allotted the petrol pump. SPCL has allotted the petrol pump. All NOCs we have received. DC has given an NOC, the Deputy Commissioner, on the recommendation of Range Officer of Forest. Now they are saying this is a forest land.
I will kindly go through.
So let them file an affidavit.
Bring it on record.
Yes, thanks. And I don't have the affidavit. They say that circle officer has filed an affidavit, no, that has not been served to us also.
That circle officer is council for circle officer. Why
I'll
don't you have copies to
I'll get
council?
her.
That
Yes,
is
I'll be filing. I'll be serving both, my lord.
All councils must be given copies of pleading filing.
Lordship, there is some urgency in the matter, Lordship.
Jay Kolita appears for the reputation. And Mr. A. Gogoi for the forest, submit that he has received instructions like by court, Mr. N. Goswami. Mr. S. Kothakpur.
Number 10 minutes.
Respondent number 10. Mr. Ravapur, you are there? No.
I have accountant general.
Accountant general, what is accountant general? There's no accountant general. MSP
39.
Or? It's the counsel to the petitioner.
39.
The matter. Let the matter be listed. Mr. Gogoi, when can you file it?
2 weeks, madam.
So 1 week, he has
No,
already.
no, madam, 2 weeks, madam.
No.
There's no urgency.
No, there is urgency, there is urgency. One, not urgency, there is urgency, Lord.
No,
It's for the petitioner to.
2 weeks, madam. 1 week, I'll say, I'll go for vetting, you don't come, madam. I'll be on the again receiving else.
10 days time. File
Madam,
the
10 days, madam.
matter be listed immediately after 10 days. Date fixed to the date.
Dozy hoy wrong.
Please report.
Madam.
Petitioner?
He's for 87.
87, my lord.
He's for 87, look.
87.
87.
Yes, sir. It is my lord. Already, my lord, affidavit filed, my lord. Admitting the amount, my lord. Item 87. 240, my lord, relevant part A and 87, yeah, my lord. Affidavit in opposition, my lord, page 247, my lord, last paragraph. Total outstanding amount is, my lord, 38 lakhs, 33,828 remains to be paid, my lord. Affidavit in opposition filed by the respondent number, my lord, 4, my lord.
So taking note of this, we dispose it of.
Yes, my lord. Time frame may be given.
Third General Counsel taking part in this. Petition is filed. Agreed by the fact that or works executed by supplying various items. You supplied to whom?
Lord, in the office of the additional director general of police, my lord, CID or Assam.
Number 4. However, in spite of requests made, the bills raised for the supply undertaken have not been. Notice in the matter commission on 19/5. An affidavit has been filed by the special superintendent of police and the additional director general of police, wherein at para 3
B.
the following affirmative. The wherein wherein there is an affirmation made that total amount of rupees 38,828 is pending with respect to the petitioner, for which the same process the current. The affidavit also submits, also state, also make an affirmation that an amount of rupees 34,94,114 have been paid to the petitioner against the total bills received amounting to 73,27,940. where a learned counsel submit that in view of such categorical averment and has an admission by the respondent that the amount is to be paid, the direction be issued, the respondent is to be paid at the end. Mr. N goes on further. The respondent submits that the appears of the respondent, taking into consideration the rival submit made by the rival party counsel and also specific averment made. Board. Respondent, more particularly the respondent number 4. Who is to pay?
It is. I'm not sure already.
Respondent number 4. Process the bills regarding the outstanding amount by the tune of rupees 38,33,858 and the same be released expeditiously after that day. The entire exercise be completed within a period of 120 days from the date of receipt of the record. According to statute. Yes.
During the pendency of the writ petition, the district magistrate company has passed the order for physical possession. That is dated on 12/3/2024. I can.
Yes, sir.
Yes. They already passed the order.
Lords. I am for the private respondent, that my prayer was that only a order of that, the order was passed, but that should be communicated to us.
So you get it now.
Yes.
Give
You
him
can have, yes, he can give, sir, give a copy. Yes. I have received a copy. I have received this copy.
Right.
Now I think nothing survives in this.
So this can be disposed of.
Hard. Right. Or approve metro.
Lodge. Come with it.
Pass an order under section 14 of the SHRI Act for expeditious for taking over physical possession of secured assets or paid by respondent and take necessary steps to ensure that the secured assets are handed over to the authorized officer under section 14 of the SHRI Act. They when the matter is as placed court, copy of the order dated 12/3/2020 issued by the additional district district party, whereby it has passed the order for securing the assets of the respondent and has authorized an executive magistrate of to oversee the law and order during the process of taking over possession of the assets by the authority of the bank as described in the order itself. Copy of this order given to the court is kept in the case. In view of such order being passed now by the district magistrate, Upper Metropolitan District of Upper Metropolitan, nothing further is required. In view of the order, it is well passed by the district. That's all.
Only an observation that the petitioner had served the copy of this.
That may be recorded that he has
Yes, that
received
may
the
be
copy on
recorded.
behalf.
The order, I have got this order from the petitioner, my lord, that only an observation.
Mr. A. Das, appearing for the respondent 4 and
4
5,
and 5.
has been served a copy of this order today in court.
I'm for 120, Lord.
Mr. N.
20. Obliged. Obliged.
Lords, may I kindly pass over this matter for the day. This will require some hearing. They're claiming pension, my lords, and the AG was, these are all temporary employees, my lords. And me, AG was, no, it is not covered, my lord. It is dispute. That is the reason Lordship had may produce one order. Lordship was assistant to AG also, the finance department also. Because the pension papers were returned by the finance department that they were not covered. This will require some, my lord.
You tell us when you want to get the matter heard.
Next week, my lords, if possible, my lords, on a hearing day, my lords. I have been told there is some urgency, some patients are there.
20?
Yes, yes.
It's not 20.
Right.
Published. Of the department. There's a date. 20. 06. For hearing.
Published.
Item 89, you also tag, madam.
Item 89 is like.
Yes, along with. I will take for it.
for allowing FSL examination of the date, amount, and the name of the pay that is written on the check, lordships. So Exhibit 37 application was placed before the trial court, that is rejected. And thereafter, we preferred the revision application before the Sessions Court, lordships. The order is dated 16/4/2024, that is confirming the order passed by the learned trial court under Exhibit 37. Now, lordships, the contention of the applicant is this wise, that he admits that he had only given 40,000 rupees to the complainant. What the complainant has done, lordships, by concocting the amount, lordships, instead of 40,000, he has written 7,90,000 on the check. He has shown in the complaint that 7.5 lakh rupiya cash द्वारा આપવામાં આવ્યા છે. Tactfully, what he has done, he has withdrew an amount of 7 lakh from the bank. If he wanted to really give that amount, he could have given by way of a check, but he has just cooked a story. He is mentioning that 7 lakh is given by way of cash, which is actually not given to the applicant, lordships. 40,000 applicant admits. He has also given a sum of 50,000 rupees to the complainant's advocate, lordships. And the complainant advocate, on the pretext that we can do a settlement, you give 50,000. He has given 50,000 also, lordships, and there is no dispute that he did not take 40,000 from the complainant. Now the dispute is this wise, કે 40,000 ના બદલે he has entered an amount of 7,90,000 on the pretext કે cash માં છે. In the cross examination, he admits કે આવું કોઈ નોંધ
So
નથી.
who made an application for sending the check for FSL examination?
Lordships, the present petitioner.
And that application was rejected.
That application is rejected. And then again, against that order dated 19/3/2024, criminal revision application against the said order was preferred before the Sessions Court. That impugned order is at page 37 to 48. It is again rejected on 16/4/2024. The operative portion of trial court's order, lordships, is at page 36. Wherein it says na manjur. And the reasoning that is given starts from page 31 onwards. And lordships, the only presumption made against the accused is that you submitted 50,000, so you definitely might have taken 7,90,000. But it is not the case, lordships. And in the cross-examination, what the complainant has stated in the complaint, the accused is my friend. In the cross-examination, he says, Ame mitra nathi. Then he says, I had given the amount in presence of one Nirubhai. Nirubhai is not examined in the trial. And lordships, already when the trial took place at the first instance, lordships, the advocate for the accused never remained present, and because of which the accused was not able to go to the court. He did not know ke kyare છે date and kyare જવાનું, because of which on the date when the complainant's
Ms.
advocate
Prajapati,
please, lordships.
how these observations made by the learned trial judge can be said to be erroneous?
Lordships,
He has relied upon some Supreme Court judgment.
Please, lordships, but the presumption is drawn on the basis of the setup. Now, what had happened, lordships? Lordships, there is an application at page number
Page 32 para 11.
Please,
Page 32
lordships.
para 11 રેકોર્ડ પર રજૂ થયેલ ઉપરોક્ત હકીકતને ધ્યાન લક્ષમાં લેતા કામના આરોપીને સદર ફરિયાદ દાખલ કરતા પહેલા નોટિસ બજેલ હોવા છતાં તેઓએ કોઈ જવાબ આપેલ નથી કે કોઈ બચાવ પણ લીધેલ નથી.
Please, lordships, that I admit, lordships, that he has not given a reply.
Yes.
But lordships, here in this particular case, he did not have such a kind of legal advice.
Sorry.
And lordships,
And statutory presumption also has been considered.
lordships, but here in this case, the amount was total in cash. The cross-examination was taken after an appeal is preferred, lordships. In appeal, the matter was remanded back to learned trial court. And thereafter, lordships, there is prejudice that is happening with the accused, lordships, here in this case. The day when the complainant had submitted an application that his right be closed for cross-examination, the same day judgment is passed in the court. That appeal was preferred. In appeal, the accused gets right of cross-examination. He changes the advocate. Same day cross-examination is done. In
That is not
cross-examination,
an issue before this court. You want the check to be sent to FSL.
Please, Lordships.
The trial
Lordships,
court has, by relying upon the judgment of the Honorable Supreme Court, has taken a view that that is impermissible.
Lordships, here in this case, if that, because the amount, the name of the payee has
Whatever,
not been,
you have not even bothered to reply to their notice.
Lordships, at that
Had
relevant,
these been your defense right from the beginning, the things would have been different.
Lordships, those contentions have
Now
been
you
taken
suffer for
later on.
whatever lapses are there on your part.
Lordships, on some terms and conditions, this may be allowed. Lordships, in a stipulated period also,
Maybe.
the exercise can be completed.
Sorry, madam, I'm rejecting it. What do you want?
Lordships, here in this case, he'll have to face a sentence for no fault of him.
Maybe. Therefore,
Because the entire,
one should be vigilant. If he receives a notice under Negotiable Instrument Act, he is expected to reply it immediately and deny the contents.
Lordships, once page 107 may be seen cross-examination.
Yes, 107. What do you want to
Lordships,
point out?
Please, Lordships. Lordships, in that cross-examination, the complainant himself is stating that he basically has not page 107. Just for a moment. Lordships, this is his cross-examination. He himself states opposite facts as that he had mentioned in the
Yes, but then
criminal
it will be
complaint.
considered by the trial court. No need to send it for FSL examination.
Lordships, because even if Section 6 of the Negotiable Instrument
No,
Act is
in
seen,
fact, the trial
if-
court has relied upon Section 118. Turn to
Lordships, Section 118 presumption, but presumption is drawn on the basis of that settlement, that 50,000
No.
which was given. Now, Lordships, that 50,000 also was
No.
given in absence of advocate of the accused.
sorry.
At that point of time, only complainant's advocate is present
Sorry,
and
Mr.
complaint.
Jagati. What do you want?
Lordships, only a request on some terms and conditions. This
No terms. These both the orders are absolutely perfect. No error committed by trial court or appellate court.
Lordships, there is one judgment of Sashikant Sharma. Lordships, my learned colleague will be passing the
Yes.
judgment. Lordships, Sashikant Sharma, though the facts are a bit different, but here also the ink was different and the details were filled in with a different ink. Para 11 and 12 are relevant in that judgment. And this judgment is passed on the basis of decision which are rendered in T. Nagappa's case. So, Lordships, here in this case, the check was filled after there was a delay of 7-8 years. In our case, there is no such delay. But then the details were not filled in by the
It was only for determining the age of the check, not the signature.
age, and also,
Read
Lordships,
para
here
one
age
of
of
the
the
read para one of this judgment.
Lordships, it is
Father
Lordships,
aging and
Lordships, para 11, there is a sub-para given. There it is written comparison of ink also that is used for the text of the body. So signatures ink is different and the text of the body's ink is different. Para 11, there is a sub-paragraph which is quoted. It says the applicant has disputed, age is disputed, which is not our case. But
para
what is
3,
this?
para 3, what was your contention? It was not that it is not your signature. Para 3, read para 3 of that judgment.
Please, Lordships.
So and so submitted that the petitioner denied the charge and therefore the trial court proceeded to adjudicate the matter. During the course of trial, the petitioner gave an application below Exhibit 32 for handwriting expert's opinion for the aging of the ink and writing on check, as well as the opinion of handwriting expert
Please,
to avail
Lordships.
the benefit
So-
of defense.
Please, Lord. So here, I do not contend for age of the check or age of the ink. But comparison of the ink of the signature and the
No,
amount and name.
your say is that signature you are not disputing. You are admitting it as far as 40,000 rupees is concerned.
Please,
You are
Lordships.
disputing the amount.
Amount, yes.
Yes.
And lordships, based on that settlement, 50,000 already has been given to the
Maybe.
complainant. And that application is also on record on page number 65, 65, 65A and 65B.
So as far as check is concerned, you are not disputing. You are not disputing it as far as amount of rupees 40,000 is concerned. And therefore, I also don't see any reason to send it for FSL.
Lordships, only last submission. Instead of 40,000, they have filled the amount of 7,90,000.
That is a matter of evidence. But you have already cross-examined them. It has
Please,
nothing to do with FSL examination.
Please.
What do you want?
Lordships, I'll withdraw in that case.
Chalo, seeks permission to withdraw.
Please, Lordship. Obliged. May I leave, Lordships?
Yes, you may leave.
Please, Lordship.
Number 72, Mr. Yogesh G.
My lord, as per for a 13%.
Yes.
Annexure G, the real incident took place at Annexure G, page number 52, Lordship. And when the applicant say, no, I will not avoid to lodge FIR, then and then only counterblast this annexure at Annexure C, FIR was lodged. My lord, the petitioner not go out of the house, and therefore 135 also not applicable, and due to bilateral knee replacement, he cannot run away. All 14 statements of the charge sheet is only fabricated. The 50% come to the police station and police also subdue.
Look at the allegations, page 28.
Page number 28. Yes.
In the past also something has happened.
This is my lord, acquittal. Past criminal case number.
But this constitutes an offense. Charge sheet is filed.
My lord, charge sheet.
After investigation, something is found against you.
My lord, after charge sheet, but yet not frame charges, lordship. Before framing of charges.
You face the trial and here also you get the clean acquittal.
My lord, what happened that in this FIR lodged by the applicant is a issue notice, lordship.
Mr. Kanade, the witness is also deposed in line with what is stated in the FIR, page 33, 34.
My lord, all witnesses are accused in the rioting case, lordship.
Maybe this is your petition for quashing.
Yes.
I am not inclined.
Pass reason order. Please,
make your submissions.
Annexure A, that first of all, before charge sheet, I have preferred quashing, but I have chosen that no. And therefore, Honorable Court pass clear order that with a liberty to file fresh application if needs to arise in future, and therefore this present application, Lord. Thereafter, my lord,
Mr. Kanade, I don't mind passing a reasoned order, but you being an advocate, I would suggest you to give it a second thought. Mr. Popat, you
discharge also rejected. Lordship.
Now I cannot advise you, but you seek advice from some Mr.
My
Popat
lord,
or someone who is
Lordship,
exclusively practicing on criminal side.
If my lord,
Mr. Sayyed is also there beside you.
My lord, kindly see that how I am apprehended.
There is everything against you.
This is not a way, lordship. I am only one person, isolated person in the society, and therefore all members of the society assaulted and police also subdue before mob.
I am not saying anything. You may be right, you may be wrong, but then it's a matter of evidence. It cannot be cost like
Matter of
this.
evidence, but then what is credibility of these 14 witnesses? 14 witnesses are accused in the rioting case, Lordship. 9%, and I have filed 319 application, which is also rejected. But my lord, it does not mean that I have further course of action stop. And lodgement of FIR also have done. And
You can
thereafter,
avail whatever remedy you want to avail. You have availed this remedy. If you want, I don't mind passing the reasoned order, but it may affect you and your career. That's why I'm disputing.
I have filed 173(8) application also to further investigation.
You must have filed all the available applications that is prescribed under Criminal Procedure Code. But
Lordship,
I am concerned about this.
Lordship, I am advocate and I can also challenge order before. I have filed already, I rejected. I have already filed revision, but what about my right to quashing? I want to, if not quashing, then reason order may pass. I can challenge before Supreme Court.
Do it. Chala.
If this is
Yes.
history
What
of
are the ground-
violation knee replacement and this 14 witnesses, he is running and go. But actually he was not come
But
outside
in
of the house.
quashing, can court say that those 14 persons are wrong? And
They
you are right.
14% how wrong? Because they are accused in the rioting case. They all are enter inside house. And my Panchnama, she read my Panchnama. My car was broken. My house was
Someone may be accused in a different offense is a different thing, but here someone is victim as well.
If 100% is united, that does not mean that one person have no right to live.
Who questions your right?
નુકસાન થયેલું મને કેર નથી પણ મને I don't care about my loss and
અરે ચાલો કોઈ નથી પણ you care about
if I am not allowed,
You care about
I don't want I don't care about my loss. I don't care about my career. If person
Then I will pass the order. I am not saying no. I just
the court cares
put
about
a word of
please.
caution.
No, but if court even not giving me simple relief for next date of hearing, then my lord, what can I do?
Yeah.
If this decision,
અચ્છા કાલે મુકાય
I am not innocent. This court means I am not innocent. This FIR at NHSC is not abuse of process of law. When incident not happen, before CCTV camera, no prudent person go before CCTV commits crime. And all
Mr.
14
Kanade,
witnesses
Mr.
have said,
Kanade.
why, they are nowhere mentioned that there is CCTV camera in the Panchnama also. There
As a
was no
person,
mentioning.
as a person, after having practiced before this court for 23 years, I will have sympathy for every advocate. But as a judge, I will have to look at the papers.
કલ રાખવા દો કલ we will deal with it. I'll be there with you. We'll deal with it. કલ રાખવા દો. Please. Let it be
I
tomorrow.
fail to understand, Lordship.
No,
I fail to understand why
I understand you are
no
party
prudent
to it.
person go before CCTV camera and committing crime, Lordship. And therefore, my lord,
I am not saying you are wrong, but I can't say that you are right as well.
અરે એ issue જ નથી કાલે મુકાય
Please, Lordship, keep on tomorrow.
Tomorrow or whichever date you want.
Keep on day after tomorrow.
Day after tomorrow.
Please, Lordship.
Lord, this is against issuance of a non-bailable warrant.
Yes.
Now, the position is of law, my lord, two things. One, that a non-bailable warrant can't be issued in aid to investigation because there are a number of judgments, my lord, which I am relying upon. It says that the powers of the police to arrest and accuse are independent. And that is a statutory function. The court doesn't come in the picture. Now, my lord, two. So therefore, for arresting an accused, the police can't take aid of issuance of a non-bailable warrant by filing an application before the concerned court that sees the accused, we are unable to arrest the accuser, therefore issue a non-bailable warrant. So that is one thing, because 41 is independent of 70. I'll point out from the judgment. This is one thing. If at all the court wishes to issue a non-bailable warrant for production of a person before the concerned court, not before the police, then in that case, there should be a summons, then a bailable warrant not complied with, and then issuance of a non-bailable warrant. That's the position of law. Now, in present case, the police filed an application that the application for anticipatory bail is rejected, and therefore kindly issue a non-bailable warrant under 70. I'll come on that, my lord. I'll just read it. The court, my lord, says that police is unable to arrest, and therefore they are seeking issuance of a non-bailable warrant and non-bailable warrant issue, which is again, my lord, a violation of the settled legal position. And please see now the application, my lord, which is at page 56.
Yes. Yes, page 56.
My lords, is it that SHRI additional senior civil judge?
Page 56 is a part of some judgment. Internal page 6 of page 36.
I'm sorry. It's 15, my lord. I'm so sorry.
15.
I'm so sorry.
That's right. Yes.
Then please see, my lord, page 17, 17.
Yes.
It refers to two applications for anticipatory bail in the 5th line. Criminal miscellaneous application 2260 and criminal miscellaneous application 3014. આગોતરા જામીન મેળવવા અરજી કરેલ છે જે નામદાર કોર્ટમાં નામંજૂર થયેલ છે. સોએનસો ભરૂચના નામદાર એડિશનલ જજ સેશન્સ કોર્ટ આગોતરા જામીન માટે અરજી કરતા નામદાર કોર્ટે નામંજૂર કરેલ છે, તેમજ નામદાર ગુજરાત હાઈકોર્ટે આગોતરા જામીન મેળવવા અરજી કરેલ છે, પણ નામદાર કોર્ટે નામંજૂર કરેલ છે. સદર આરોપીઓનો ગુનો કરવાની ટેવવાળા હોય, પોલીસ કાર્યવાહીથી વાકેફ હોય, સે આરોપી સાથે મળી ગુનો આચરેલ છે. અમારા અંગેત બાતમીદારો દ્વારા મારફતે આરોપીઓ મારફતે હકીકત મેળવવા તજવીજ રાખેલ છે, અને આરોપીઓ એ બાબતે કોઈ હકીકત મળી આવેલ નથી. જે આ કામે સદર ઉપરોક્ત જણાવેલ આરોપીઓ હાલના નજીકના ભવિષ્યના સમયમાં મળી આવે તેવી શક્યતા ના હોય. સદર બંને ગુનામાં તપાસ, now last two lines, તપાસમાં રહી પકડવા માટે નીચે જણાવેલ નામવાળા આરોપીઓને CRPC 70 મુજબનો વોરંટ ઇસ્યુ કરવો. Now please turn to the impugned order, which is at page 10.
Yes.
અંકલેશ્વર સોએનસો 4th line from the top. જે અરજી હકીકત તથા કેસ ડાયરી વંચાણ લેતા સામેલ નિવેદનો વંચાણ લેતા ગુનાનો તપાસે આરોપીની સંડોવણી જણાઈ હોય છે, તેમાં આરોપી પોલીસ અટક કરવા સારું ઓળખાણ છુપાવી નાસ્તા ભાગતા ફરે છે. તપાસ કરનાર અમલદાર શ્રી રહેતો હોય જેથી આરોપીની અટક કરવા સારું પ્રયત્ન કરે, તેમની અટક થતી અટકાવવા પ્રયત્નશીલ સોએનસો, and then in the end it says કે 70 મુજબનો વોરંટ કાઢવામાં આવે છે. So the sole reason for applying the for non-bailable warrant is for arrest. The order is passed on the basis of that the police wishes to arrest him. Now please see, I'll straight away take my lords to my lord the first order, that is page 89, the first judgment. Eighty-nine. This is exactly the same issue.
Yes.
And at 108, para 14, my lords may see, at 108.
Yes.
Thus, the Supreme Court has held that the warrant of arrest under 73, the form is under 70, my lords. The powers are to be exercised under 73. The order is to be passed under 73. There is a format which is to be filled up, and that is the non-bill warrant and 70, my lord.
Page
So,
108, where are you reading?
my lord,
Para 16?
Para 14, my lord.
Para
I'm sorry.
14 is 107.
Para 14, my lord, sir. Does the
107.
Supreme Court? Does the Supreme Court?
Yes.
I'm so sorry, my lord. There is
That's
some.
okay.
Thus, the Supreme Court has held that the warrant of arrest under 73 of the code cannot be issued by the court solely for the production of the accused before the police in aid to investigation. Now, please see, my lord, I'll take my lords to another judgment at 19. 1-9.
Yes.
Now, at 32, para 17.
Yes.
In absence of any specific provision in 41A of the CRPC for an order from the court for issuance of a warrant, and when section 41A itself permits the police officer to make an arrest, no orders under 73 would be warranted, and no order under section 73 made to aid the investigation.
When there is no specific.
Yes, my lord. Now, this is one part. The second part is that supposing the court wants the production of the accused before it, then I'm covered by a Supreme Court judgment which says there is a procedure, because you are taking somebody's liberty. So there is a procedure. You first issue a summons, not complied with, bailable warrant, not complied with, then a non-bailable warrant at the end of it. Here, nothing is done. Only within it will be to aid the investigation, the warrant is issued.
You come at around 3:30 because
Very
2:30
very well.
matter is
3:30.
kept, and thereafter there are 2-3 consent crossings. So
Very
around 3:15,
Please,
3:30. So that
please.
by that time you
Yes,
can.
yes, ma'am. Yes, ma'am. Grateful. Grateful.
both the writ petitions are dismissed as they are devoid of merits. Interim order passed earlier on both the petitions are vacated and stroke recalled.
I will also be automatically sent this.
I will do. Okay.
Yes, Mr.
No, I make a mention of item, Milord. I have some personal problem today, Milord. Item 40, Milord, order. It may be taken on Friday, Milord.
Have you gone through the records?
Yes, Lordship. Yes, sir. Lordship, in page 29, Lordship, affidavit of annual hog, Lordship, but in verification part, Lordship, it was Sirajuddin, Lordship. So this evidence cannot be acceptable, Lordship. Again, Lordship,
No,
so many.
what brother has pointed out, even there are white marks are there.
Yes, Lordship.
Even the thumb impression.
Yes.
To him.
Yes, Lordship.
Show it to him.
I've seen.
You have seen Mr. Ahmed?
Yes.
No.
This was
Yes,
being accepted in the lower court, Your Lordship.
See, basically, that's, you have seen how it is there.
Yes, Lordship. And in every part, Lordship.
And the exhibits that were not in the record, Your Lordship.
There is no mention also. You see the evidence of the DW2, I think. Affidavit in written evidence in affidavit. Mentioned, but there is nothing there. It's all been marked.
Yes,
Let's find out. Show it to him. Show it to Mr.
Yes,
Ahmed, Mr. Sharma.
Yes,
All the documents are
he
marked.
has seen, Lordship. Lordship,
So there is, it was not placed before the tribunal.
The 28 page, Your Lordship, DW1 of the petitioner. Here she has stated the exhibits, all the exhibits in serial order.
He might have.
Yes, Lordship.
Exhibit 3, we can understood. Exhibit 7.
Exhibit 7,
But the
exhibit
record
6.
was not placed before the tribunal.
nowhere, Lordship.
So, Lordship, in the cross also it has not been raised that they have not.
So all those documents are there.
Yes.
That is why you peruse the original. Everything is in original. See whether exhibit 7 is available.
But as per the instructions of the petitioner, she has stated that she has submitted in original before the court. And same has been also accepted in the DW1 has been written as down in there, point-wise para. And same has not been objected by the learned PP also.
No.
Nothing has been said by
My
the
lord,
tribunal also in the opinion. There's nothing
In
has
her
been-
evidence, Lordship, exhibit 1 is the 1966 voter list, exhibit 2 is the 1970. It is also in the record. Exhibit 3 is the 1977, exhibit 4 1997, then Lordship, exhibit 5 is the 1979, and exhibit 6, Lordship, that my father is having landed property in his name. That part is not here in the record, Lordship. And exhibit 7, that is Sarkari Gaubura of Farmerpar village, has issued a certificate that it is also not here, Lordship. And Lordship, both DW1 and 2 made contradictory statement,
Give us the
Lordship.
record.
Borua.
The proceeding in her cross examination has mentioned which other documents she has related.
Yes, sir.
Thank you, Mr. Ravi.
In WS Lordship, he is telling that I was born at village Lankagan, but in evidence Lordship, he is stating that he was born at Dorji.
Your Lordship, it is stated that exhibit 1, 2, 3, 4, 5 are being exhibited, whereas the exhibit 7 is also present there. And it is an exhibit 7 according to the evidence is 1966 for release.
No, exhibit 1.
Exhibit 7 लिखा है.
There is no link, Lordship.
Heard Mr. S. Secure, counsel appearing for the petition. And Mr. P. Sharma, Ladakh CGC for respondent. Also heard Mr. G. Sharma, standing counsel, Home Department for respondent. We went to HK Agricultural Government of Assam for respondent. And Mr. H. Kuli, standing counsel, for respondent. We lose the record. FT of the L of the case number 69 of the 2016. The learned foreigners tribe. No bound put up. Decided on 15 to 19. Set up for Burundi include judgment of cross party 1502. It was called for by order 17. 12. Order. Okay, you get it.
Hable.
Yeah. Yeah.
Just a minute. Pursuant to the order of the court, pursuant to the earlier order That is 19/02/2019. And 8/5/2024. Earlier in this proceeding, the Superintendent of Police Order Bongaigaon submitted the inquiry report dated 30/05/2024. Pertaining to the school certificate dated 18/09/2012. Placed by the petition. The said report of the Superintendent of Police Order Bongaigaon placed before the court today by Mr. G. Sharma, standing counsel. Be placed by way of an affidavit to be filed by the Superintendent of Police Order Bongaigaon, Respondent number 4, on or before when 28, serving a copy of the same on the counsel. Placed on 16th July. File your affidavit.
Yes, Lord.
Notice in this case was issued on 06/09/2017. In the records of the case, records of the April 11 FP case number 1614 of 2011. Wherein the impugn opinion also passes on 02/08/2017 was also called for CLLP from the Foreigners Terminal Kamrup Metro number 1 of Gujarat. The petitioner is an interim protection and interim bail since 06/09. The name of the council has been reflected in the court list. Council for the petition. But the petitioner remained unrepresented when the matter was taken up for consideration. Even on last two occasions, i.e. on 07/06/2024 and 08/08/2019, the petitioner remained unrepresented. Petition stands dismissed from the proceeding. The interim order passed earlier on 06/09/2016. Registry shall enter the records of application number 164 of 2011. For the landed furnace tribunal, Kamrup Factor number 2, court with the number of this. The registry shall also inform the Commissioner of Police to indicate border. Kamrup Factor. Shall also inform the copy of Mr. Registration. Notice in this case was issued on 16/9/2017. Registry received the relevant records from the furnace tribunal 6 to 3. That was called for by order at 69. Petitioner is also in protection and bail since 16. Rule hearing shall appear before the Supreme Police order to bring on or before 2nd of July for capturing her biometrics.
My pleasure.
Notice in this case was issued on 22/09/2017. That is the receipt the relevant records from the furnace tribunal. Petitioner is since 22/09/2017. Hearing appear before Supreme Police for border to private on of for capturing
My lord,
is
I'm sorry, my lord, I have one submission, lordship. And in this case, lordship, the initially and he's not fulfilled the trial, lordship, and the foreigner tribunal. And lordship, and as per the judgment, and kindly come to page number 41. And that it's a case of remand back and retrial and only at the stage of evidence and cross the documents and witnesses, lordship, and he leave the court, lordship, and subsequently expert order has passed. Civil lordship, and he is ready to. Page number 41 is the relevant supporting person, and may I read, lordship.
Please, the after tomorrow.
Published, lordship, published.
No representation on behalf of the petitioner on court. Two names of 3 counsels have been declared in the court test. List after a week on a date. Tarakota Kali list after a week or about it. Petitioner is interim protection, interim bail since 22/09.
An impugn order appears 29/5, 27. Page 27.
Notice in this case was issued on 22/09. The registry received the relevant records from foreign tribunal number 2 Kamrup. Poco, interim protection, interim bail 22/09/2017. Rule Poco, interim protection, interim bail 22/09/2017. Rule hearing. APF before Supreme Police ordered Kamrup Patamina on or before for capturing hardware. Correct. Notice in this case was 2209/2001. Registry received the relevant records from the Furnace Terminal number 2 and Viable. Furnace Terminal Bongaigaon number 3. Interim protection, interim date 2209/2017. Rule hearing to appear before Superintendent of Police Border Bongaigaon for capturing his biometrics. Right. He is in.
Oblige, your lordship.
Notice in this case was issued on 2209/2017. The registry received the relevant records from the Furnace Terminal, Nagaon, Court number 7 at Longta, Ujai. Interim protection, interim bail since 2209/2017. Rule hearing shall appear before the Superintendent of Police Border Ujai on or before second for capturing hard. Notice in this case was issued on 22/11/2017. Registry received the relevant record from Furnace Terminal number 1 for first Furnace Terminal first. Interim protection, interim bail since 22/11/2017. Rule hearing appear before Superintendent of Police Border Morigaon on or before 2nd July for capturing his notice in this case was issued on 10/11/2017. Registry also received the relevant records to the Furnace Terminal number 8 corporate. Petitioner is in interim protection in bail since 10/11/2017. When the matter was taken up for, when the matter was called for adjudication, the petitioner remain unpresent through name of two counsels have been reflected in the court list. Even on last occasion, the petitioner remained unrepresented on 07/06/2024. And the court master of this court on 07/06/2024 itself informed the counsel for the petitioner in his email regarding fixing of this matter today. In spite of that, the petitioner remained unrepresented. Such dismissed for non-prosecution. Interim protection, interim bail, the retainer stands packeted record. Return the record of a copy of this on the Furnace Terminal. Superintendent of Police. Copy of this order to Superintendent of Police Border Borpeta. Copy to Mr. Jason. Notice in this case was issued on 02/05/2018. Registry received the relevant records from the Furnace Terminal. Nagaon, Court number 10, Sankatarnagar, Gujarat. Petitioner is interim protection, interim bail since 02/05/2018. When the matter was taken up for consideration, the petitioner revealed two names of two counsels of the reflected in the court. Even on last occasion, 7/6/2024. the petitioner remained and everything. Dismissed for not prosecuting. Order dated 2/5 for the interim protection, interim packet of same order. Ali Supreme Police order. Song protect number for the G Sharma. Notice in this case was issued on 7/5/2018. The justice received the relevant reports from the Finance Tribunal of Court number 10 and Supreme Court that was called for by order of the petitioner is also on interim protection, interim bail since 7/5/2018. Same order. Names of two conflicts for the purpose. Even in last petition, I-76/2020. Interim bail protection. Date to private interim bail interim protection. 7/5/2020. It under record. Along with a copy of this one. Supreme Police order for that. G sir.
But please, Your Lordship. That's it. Since long days have failed to communicate with the petitioner, Your Lordship, some time may kindly be allowed, Your Lordship. That case was not listed for a long time.
On the prayer of the council for the petitioner, place this matter for admission on 16th July. Registration in the relevant records. Notice in this case was issued on 16/8/2018.
The Lordship,
Registry also received the relevant records from the Finance Tribunal 8 Sonitpur.
Your Lordship, in this case, Your Lordship, the petitioner was in detention for 2 years, and thereafter, Your Lordship, based on the general order passed by the Apex Court, Your Lordship, he was released.
Sonitpur, Kalamara. Petitioner is interim protection since 16/8/2018. Issue rule. Let the matter for hearing. It is submitted by Mr. Hussain, counsel for the petitioner, that the petitioner was taken into custody, was in the detention camp, was detained and kept in the detention camp pursuant to the impugned order dated 15/03/2018, passed by learned Finance Tribunal 8 Sonitpur at Kalamata, Assam. She was subsequently released after 2 years of her detention. But it's according to for getting on it to be expected. Notice in this case was issued on 26/07/2018. Registry has also received the relevant records from the Finance Tribunal 2nd Gauhati. that was called for by order dated 26/07/2018. Petitioner is also in interim bail and interim protection since 26/07. When the matter was taken up for consideration, the petitioner remained unrepresented. Two names of three counts. Even on the last occasion, on 07/06/2024, the petitioner remained unrepresented. Dismissed for non-prosecution. Interim protection and interim bail, dated 26/07. Open the police border now. Copy of your certificate. These are.
My lord, kindly see, NHR 8, my lord, it's number 23, 33. There is no remark against the petitioner other than his name and address. Page 33, my lord.
Yes, please make your submission.
My lord, he is genuine India. He is, my lord.
Heard Mr. NH Madhav being counsel appearing for the petition. Notice in this case was issued. Notice in this case was issued on 09/08/2018. Registry also received the relevant records from the Foreigners Tribunal, 9th Corporate Assam. Issue release the matter for hearing on a date to be fixed by the registry. As by the impugn opinion dated by the impugn judgment and order dated 14/02/2018 passed by the Foreigners Tribunal 9th Corporate. In FT9 case number 143/16. Impugned in this petition. Petitioner has been declared to be a foreigner under the Foreigners Act 1946. Who had a legal right to take a territory of India on after for a date. Okay. Subject to his appearance before the Supreme Police Court of Borpeta on or before 2nd July. In obtaining bail condition for it, he shall not be taken into custody or detained in custody if not already arrested. Shall not be deported from the territory of India until further. Conviction for it. Hearing correct rule hearing. Appear before the Supreme Police Court of Borpeta.
Lordship, the council has a personal difficulty. Kindly adjourn for 2 weeks.
Notice in this case was issued on 15/02/2019. Registry also received the relevant records from the Foreigners Tribunal, Gauhati. This was called for by order dated 15/2019. Petitioner is also in interim protection since 15/02/2019. As by the impugned judgment dated 11/10/2017, the petitioner has been declared to be a foreigner under the Foreigners Act 1946, but illegally entered into territory of India in the Assam on or after 24/03/1960. This shall appear before the Superintendent of Police Board of Golaghat on or before 2nd July. But the condition subject to bail due. Okay, rule or guarantee. Notice in this case was issued on 06/03/2019. Registry already received the relevant records from the Foreigners Tribunal past Mongol Dorong. Petitioner is interim protection since 06/03/2019. As by the impugned judgment dated 07/09/2018, was by learned Foreigners Tribunal past Mongol Doi in FT case number 2102/2011. Declared the petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered the territory of India within Assam on or after 25/03/1971 to the specific territory of specified. उससे पहला लेखन रूल हियरिंग कर नोटिस रिकॉर्ड इंक्लूडिंग प्रोटेक्शन प्रॉपर्टी टू रूल registration letter matter for hearing on a date to be appeal. Petitioner shall not be taken into shall be released on bail subject to the condition interim protection लिखा है interim protection date अलग है ये है 21/12/2008 cover rule hearing correction shall be released on the subject to condition that she shall appear before the Superintendent of Police Board of Mongol Doi, Dorong at Mongol Doi on or before 2nd July. But condition that.
Obliged Lordship.
Hey. Notice in this case was issued on 13/05/2019. The registry received the relevant records from the foreigners tribunal second Morino. It was called for petitioner's interim protection and interim bail since 10/5/2019. Rule hearing shall appear before the Superintendent of Police Board of Tinsukia on or before 2nd July for capturing of our biometrics, fingerprints,
Good.
Notice in this case was issued on 17/7/2019. The registry already received the relevant records from the foreigners tribunal number 1 Valpara. Petitioner is interim protection. No. Take your,
My lord, this case is.
take your seat.
Good, very good.
Yes, what do you have to say?
My lord, in this particular case, this thing, we have challenged the order dated 1/1/2011 passed by the Learned Foreigners Tribunal, Gwalpada. In this case, the main ground that was
No, no,
taken
no,
that the
no.
original.
Why the mother and wife have made petition? We can understand mother has become a petitioner because the petitioner number 3 and 4 and minor at that point of time.
My lord,
But why the mother of the prostitute has appeared?
my lord, if my mother is the Indian citizen, how her son can become the foreigner? And it is the, if lordship kindly peruse the annexure number 61 type copy, there by this order, the Honorable Foreigner Tribunal, that is at that time it was IMDT, Tribunal had declared that the mother is the Indian citizen.
Have you placed those documents?
It was type copy is page number 61 and 62. The copy that we have annexed is the original is 63.
I will not just put anything.
There it has been my mother, that is Anima Das. After marriage, she is Onima De. She has been declared that she is an Indian citizen.
There's this matter for admission. Yeah. The two, right? Put in.
Deeply.
Notice in this case was issued on 22/05/2019. Registry of the received the relevant records from the partners tribunal second council. Petitioner is already interim protection in interim bail since 22/05/2019. Issue rule. Place this matter for hearing and it will be fixed mechanism. Good night. Copy submitted. God bless. Yes, Mr. Sharma. What happened? Till the records haven't been received. You have served your copy. Matter is pending since 18th of March 21. We have received a copy on 21st of May.
Lordship. Lordship, 1 week time may be allowed, Lord.
Notice in this case was issued on 18/3/2021. The record of case number FT within bracket 2-537 of 2006 was called for from the Finance Tribunal Second Dorong at Mongoldoi, wherein the tribunal passed the imprint judgment on 30/10/2017. Was called for. Office notes reflect that in spite of issuing reminders on 17/03/2022 and 22/05/2024 pursuant to the orders of the court dated 14/3/02/2022 and 17/05/2024 respectively. The registry is yet to receive the records of said case number FT within bracket 2537 of 2006 from the Finance Tribunal number 2nd Mongoldoi. The Mongoldoi Finance Tribunal FT case number लिखन 537/2006 लिखें. Which was subsequently renumbered. As UDL oblique FT case number 511 oblique 2016. before the Foreigners Tribunal, Udalguri. Due to change of the jurisdiction of the case, since the petitioner is from village number 1, Sunazuli, under Paneri Police Station of District Udalguri, erstwhile district or Freestone. (2706/2024). Federal on the part of the Foreigners Tribunal number 2nd Dorong. Sorry, 2nd Foreigners Tribunal, Udalguri. To provide with the records of UDL/FT case number 511/2016. Okay. So, 55. No, 537. 537. This is not the incident. 30/10/2000. This is an order of 2206/2000. Mr. Sharma.
Yes, Lord.
We are not passing any order because you see this particular matter might have been transferred to the Foreigners Tribunal, Udalguri.
Yes.
Wherein it has been renumbered as something else. We do not know what is the number.
Yes, Lord.
Because this case was. Do you have the copy of the petition?
No, Lord.
Anyway, page number 11.
Yes.
It was initially registered before the Foreigners Tribunal 2nd Mongolway. Yes, bro. But if you see the address, you will come to know at page number 11, it is the petitioner is from number 1 Sonazuli Police Station, Paneri. Yes, bro. Udalguri. Yes. But decision was earlier because there was no such foreigners tribunal. Now matter has been transferred back to the Superintendent of Police border. Udalguri. Udalguri. Yes. Please answer. Enabling the Superintendent of Police border Udalguri. As well as the Foreigners Tribunal Udalguri. Provided the records of case number F.T. within bracket 2537/06 arising out of SP inquiry number 13,747/98. That was decided by the Foreigners Tribunal 2nd Mongoldoy on 22/06/2007, where the petitioner is from number of village number 1 Sonazuli under Paneri Police Station of District Udalguri, erstwhile District Darong, failing which court shall consider to pass consequential order against the erring personnel / official. Copy of disorder, registry shall communicate disorder to the Foreigners Tribunal Udalguri as well as Foreigners Tribunal second Mongoldoy district, the wrong Mongoldoy, and also to the Superintendent of Police Board Udalguri as well as Superintendent of Police Board Sorong, Mongoldoy for the necessary compliance. Copy of this order to Mr. T. Sharma.
Deeply obliged, Lordships. Lordship, in this case, matter may be fixed on next week, Lordship, because Payang may have some instruction, Lordship, regarding.
When do you want? Next week?
Next week, any date, Lordship, Monday, Tuesday.
On the prayer of the council for the, on the prayer of Mr. G. Sharma, Standing Council, Home Department. Matter is adjourned for a week. The matter may take to be.
Which matter taken after some time.
After?
Sometime. After some time.
We'll have it after vacation. After vacation.
My lord, 18th, my lord. 18th July.
Or when do you want, Mr. Khalid?
My lord, day after tomorrow.
No, not day after tomorrow.
Okay.
Day after tomorrow.
No,
18th.
18th, my lord.
18th, coming Tuesday.
Yes, ma'am.
On the prayer of the council for the parties, list on it.
Obliged.
9.
May it please your lordship, list it after vacation, lordship.
Yes, on the prayer of the council for the parties. That is the matter after I'm seeing summer vacation. When I get to be fixed by the race. Yes, APDCL. P2 okay. So 14 months, 2020. Yes, Mr. Sharma. Now just clarify few things. Yesterday also we said. Now, as per your reply before the learned single judge, you have issued format 18 for temporary disconnection of electricity supply on 16th of November 2021. And you have given him 45 days to make the payment of the area. Now, as per the rules, the regulation, format 18 is required to be issued within 24 hours of temporary disconnect. But nonetheless, here we assume that it is not that particular date on which you have temporarily disconnected. It was on only, let us assume it was disconnected on 15/11/2021. According to you, because notice was served, though you have mentioned that it was disconnected sometimes in 2020, but format 18 was issued on 16/11/2022. We have to assume that it has been terminated on 15/11. And in spite of that, the petitioner did not deposit the area. Now, for issuing, there is no further necessity of issuing any further notice.
No, madam. Format 20 is not applicable. They do not have any kind of agreement. That is permanent disconnection. The wording is such, provided in the service of the consumer remains continuously disconnected for 180 days, not being a temporary disconnect. Upon request of the consumer, the agreement shall be deemed to be terminated on expiry of 15 days or after expiry of initial period of agreement, which is later without prejudicing the right of the right or the consumer under an act for recovery of any amount due under the agreement. Any amount due under the agreement. After termination of all agreement, the licenses shall give the consumer in the format 20. Format
So,
20,
no,
that's page
that is,
5.
that's why, that. The format for temporary disconnection is 8.2. And the licensee is required to intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of disconnect. Here, you have not issued this notice.
Hello, I have issued for format 18.
You have issued
Format 18.
through the bills.
No, my lord. Format 18 has been separately issued on 16/11/2021 as per the format.
Format 18 is required to be issued within 24 hours of disconnect,
Yes, my lord.
which you have issued on 16/11/2020.
Yes, after that, you do not have to issue anything, my lord. Because as my lord, I may refer regulation. My lord, the regulation is there. My lord may see at the request of the consumer. However, at the request of the consumer will not be applicable here. However, the supply shall be disconnected only if the cause of disconnection is not removed within the notice period. So the notice period as per format 18 is 45 days. So, however, the supply shall be disconnected only if the cause of disconnection is not removed in the notice period. Now, my lord may refer to page 85. This is to inform you your supply has been temporarily disconnected with effect from 28/2020 due to following reason: non-payment. The reason is because you have not paid the amount. You are requested to remove the disconnection, intimate this offense, and you are also requested to pay some so and so towards disconnection and reconnection charges if the cause of disconnection is not removed to satisfaction of this office and above amount is not paid within 45 days of this notice, 18, my lord.
Mr. Sharma, just clarify why format 20 is not required to be given.
My lord may refer page 504 of the of your the book, my lord. Here. Okay.
Unlayered, you gave us one copy. Yes, 50.
My lord may first refer to page 406. From page 403, page 403 is disconnection and reconnection. The supply may be disconnected by the license temporarily. Disconnection, 8.1. My lord, are we in the same?
Yes, yes.
The supply may be disconnected by the license company, the license temporarily or on a permanent basis as described below. The licensee may not remove service line meter in case of a temporary disconnection, but in case of licensing shall remove service line meter, etc. The charges of connection, reconnection, and disconnection shall be in accordance with the schedule of charges specified in appendix 4 of this code. My lord, there comes 8.2 temporary disconnection. Disconnection due to non-payment of bill amount, which is where he falls in. Where a person neglects to pay any charge of electricity or any sum from him to a licensee, but due date mentioned in the bill in respect of supply, transmission, or distribution or wheeling of electricity to him, the licensee may, after giving not less than 15 clear days notice in writing to such person and without to recover such charge or other sum may be sued, cut off supply electricity under such charge or other sum together with any expense incurred by him in cutting off and reconnection supply paid but not longer. The licensee shall not be entitled to terminate the power supply in case the person deposit under protest any amount so and so electricity due from him from each month calculated based on the average of past 6 months under disputed whichever is lower. Now the 8.2.2 is a disconnection for other reasons. Now here my lord may see at end, however the supply shall be disconnected at page 404. It will
yes, yes.
Only if the cause of disconnection is not removed within the notice period. Then the licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of disconnection. Now, my lord may see page 502. I have it has been flagged, man.
Yes.
My lord may see. It's the same format we have given. You are requested to remove the disconnection and intimate this office at the earliest. You are also required to pay some so and so towards disconnection and reconnection charge so and so. If the cause of disconnection is not removed to the satisfaction of this office and above amount is not paid within 45 days of notice, your supply will be disconnected permanently without any further notice. This is format 18. So, my lord, I would like to take back to page 4061. 8.3. It's a new heading, my lord. Permanent disconnection altogether. My lord may see the supply shall be disconnected permanently in following cases. On the termination of agreement, if the cause of which the supply was temporarily disconnected is not removed within the notice period. There's a full stop there. Now there is a proviso. Provided that if the service of the consumer remains continuously disconnected for 180 days, not being a temporary disconnection, upon request of the consumer, the agreement shall be to be terminated on the expiry of 15 days or after expiring initial period of the agreement, whichever is later, without prejudice, the right of the licensee or the consumer under the Act for recovery of any amount due under the agreement. After termination of all agreement, the licensee shall intimate the consumer in the format 20 of this code. After termination of all agreement. I know now page 504 is the format 20.
Right.
The format 20 specifically says about agreement.
Okay.
That is 506. And
yeah.
I don't know, see licensing number, service consumer number. This is to inform you that an agreement dated again service connection between yourself and us. These are for the HT lines basically, or with the companies or any other high transmission lines which we have. With them we have agreement. For there is a different clause even in the AERC code. So he doesn't fall. He is a normal consumer. He will come as a normal consumer on the LT line where he asks for a consumer request. We provide him with a an electricity connection, and what we basically do, what did APDCL did for 2 long years, he has been admitted in his own legal notice which he has sent to us. My lord, I would like to take the legal notice which is at page 48, 49, my lord, of the writ appeal. His own legal notice which he has sent to us.
Yeah.
That the power connection of the aforesaid unit was disconnected. Page 49. That the power connection of the aforesaid unit was disconnected. Page 49.
Yes.
The power connection of the aforesaid unit was disconnected sometimes 2 years back by the office of SDO CEG Jew Road. That means he was aware that there was a disconnection. However, even after the disconnection of the electricity connection, the office of the SDO Jew Road continued to generate electricity bill. We have to, because until you pay us the electricity due, the charges will be come upon you. As my seniors has been settled in Manipur for long, he was not aware of the fact that the power connection has been disconnected even after disconnection. My lord may check all the bill that has been annexed from page 79 onwards till 80. There has been no energy charge reflected there. Zero energy charge. So we have not charged on consumption at all. Because when there is no consumption, they cannot be billed. My lord may see 79, page 79. Energy charge?
Nil.
Nil. It is only the area. The person who, my lord, what happens? We know our consumer number. You are aware that there is electricity. You have a house in Gauhati, or you wherever. You know that you have to pay the electricity bill. You being negligent enough to not to clear our due, and because of that, we have taken action as per the format and as per the ERC code. The entire writ petition that was filed was only under that section 56(1) notice was never being supplied to us. But 56(1) is a part of the bill itself, and that is why Leonard Singleton's finding is absolutely clear in it. That you should be aware, as a consumer, you should be aware that when you have to pay the bill. And my lord, even on record,
Sharma and Mr. Sahu.
Well,
We have a division bench to online mode from 4 o'clock. What we will do? Kali list aise.
Hello, tomorrow I have
First item.
First item.
tomorrow there is an outstation matter.
You want to do on Friday?
Friday.
my lord.
Friday. Friday first item. Madam.
After motion.
My lord, my fixed date.
We don't know. So what we'll do after motion, we'll take.
After motion. Madam.
I apologize for tomorrow, my lord. Outstation matter.
What?
Right.
Yes, please. Sister, can you hear me?
Yes, Lordship, you are audible.
Yes, please.
My Lordship, kindly come to page 17 of the IA. The person is in detention. My Lords, in this case, in brief, my Lords, the reference was of pre-foreigner. The reference was given to the FT of 66 to 71. The notice was issued to me of 66 to 71. Eventually, an ex parte, I received the notice. Page, my Lords, IA page 17, my Lords, is the reference given to FT border.
You are in review petition?
Yes, my Lords.
54.
Yes, my Lords.
Page number?
My Lords, the IA, in the IA, my Lords. There is also an IA. Right? Yes, ma'am. The reference is on page 17, my Lords. Then there is a notice issued, which is on page 37. And then there is subsequently page 14 is the order of the FT order, which is an ex parte order, making me a post 1971 foreigner. So, my Lords, our humble submission is, my Lords, in brief, that the FT doesn't have the jurisdiction to make us a post foreigner. And we are relying on a judgment by Honorable Justice HON'BLE, my Lords. It's, the judgment.
Why? What is the reason?
My Lords.
Why? What is the reason?
Reason behind, my Lords? Controls that. FT order is an ex parte order, my Lords. Our case in precise is this, my Lords, that reference was given to us of 1966 to 71. SP border gave a reference to the FT Foreign Tribunal to decide whether I am a foreigner or not of 1966 to 71. Eventually, notice was issued to me asking me to appear to adduce evidence to show that whether I am a foreigner or not of 1966 to 71. But, my Lords, eventually an ex parte is passed saying that I am a post-71 foreigner, which could not be, my Lords, which is by inquirium, my Lords, and there is a settled law. I have Santosh Das, my Lords, in pair 13, 14, 15. The entire law has been said. This has been, this judgment has also been relied in Sonakha, and my Lords, full bench judgment of Mokibur Rahman and Muslim Mandal has also been, my Lords, is also on my favor. It's, page 13, paragraph 13 and 14. May I read, my Lords?
Just a minute. Mr. Sharma. Yes, Doctor. In the IA, if the petitioner is presently placing that the notice at page 17. Placing before the tribunal that the placing before the court that the notice of the reference was made by the, it was for the period from 1st January 1966 to 25th of March 1971.
Yes, sir.
And before, now please come to page number 33. Serial number 18.
Number 18, Lordship.
Serial number 18.
Yes, Lordship.
What is it? What's written there?
After 1/1/19.
Serial number 18 by hand. What is written?
After 25th March 1971, Lordship.
Now down below, the report of the Superintendent of Police order.
It appears
to me
in a prima facie manner
that the suspect as such is a foreigner who entered into India illegally.
Yes, Lordship.
Hence the case is referred to the FT court.
Yes.
Nalbari for trial.
Yes, Lordship.
Before that, during inquiry, it appears to me, that is at serial number 22.
Yes.
During inquiry, it appears to me in a prima facie manner that Muhammad Anwara Khatun is a suspect to be an illegal foreigner as she entered into India after 25th March of 1971.
Yes, Lordship.
Without any valid document.
Yes.
So,
yes.
We'll get the records in that case.
Yes, I am in detention, my lords, and I am 63 years old, woman rights.
We'll get the record.
I may be released, my lords. I may be released.
Not at this stage. Let the
My
records
lords,
come
my
to
lords,
see.
my lords, just my lords, one more submission, my lords. My lords, if here the entire here I am standing in a much better footing, my lords. I have a footing of a, my lords, 2 full bench judgment, and there is a 2 division bench judgment. My lords, if today, my lords, if tomorrow the bench, my lords, if this honorable court decides that the FT order is void, my lords, what will happen of me, my lords? Well, please, my lords, consider the irreparable loss, my lords.
That is not the case.
My lords, I'm
Yes, yes,
64 years old
What
woman.
you
It's an
are,
ex parte. Remand back, my lords. That's all we want.
See the fun.
And
that
yes,
is why in the judgment it has been made mockery of judiciary.
Yes.
You cannot play by both ways. First of all, you had a right to appear before the tribunal. Tribunal gave you notice. You could have challenged there. What you have done, you never appeared. You have appeared through your lawyer.
Yes, ma'am.
Now, what does the 1964 order say? You did not even bother to appear. The order was passed. Let us assume it's a rightly, wrongly. For the time being, we are in the review. That is why you are not passing anything on the basis of the correctness of that order. Now, in spite of knowing that there was a matter pending before the tribunal, kept quiet. And when you have been detained in custody or taken into custody after this order, you approach this court. You didn't feel to file any repetition against that finding of the tribunal. It is not that you are not aware of the provision. It is not that you are not aware that there was a decision against you.
My lords,
it is not that you are not aware that there was a matter pending against you before the tribunal.
my lords is absolutely right on this regard.
So in that respect,
but my lords, just one line. My lords.
See, normally we allow bail, we give everything, but it matters the merits of the case.
Yes.
And Here, let us call for the records. Record was considered.
Yes,
It was
but
returned back.
my lords is absolutely right, my lords. But
You
just
will have the records next week.
But I have suffered enough, my lords. Law.
Mr. Sharma, when can you give us the record from Buxa? That's very near, not far.
Lordship,
Today is Wednesday.
Wednesday,
By Friday,
Friday,
not day after tomorrow.
next
Or
Friday,
next Wednesday, whenever you want.
next Friday,
When?
next Friday.
Wednesday,
Yes, Lord, I can get.
next Wednesday. Sister,
Yes, Lordship.
in Itanagar bench, DP is on available on Wednesday or
No, Tuesday and Thursday, Lordship.
Tuesday and Thursday.
Tuesday and Thursday, yes.
We'll have it
So
on
it can be listed on Wednesday. It's okay. If it is listed, I think.
Wednesday or Thursday, Lordship?
Thursday there is a DP at Itanagar.
Yes.
So
Wednesday.
Wednesday.
Yes.
We'll fix it on Wednesday.
Otherwise, Lordship, law has already been settled, Lordship, regard.
That you will do it later. Let us see, because he has pointed out that his reference is only with regard to the petitioner for that particular period. And has placed
It was
as-
2017 to GLT 996, Lordship. Anando Khus versus Union of India, and where law has been settled that wrong mentioning of the stream of foreigners.
2007 to GLT.
2017
Hmm.
to GLT 996.
Okay.
Wrong mentioning of the stream of foreigners in the notice, contrary to the reference, would not dictate the ultimate opinion that proceed is a foreigner of post 71 scheme.
Reference is also of
Reference is post 71, but notice.
No. That's
okay. Already, list on. (19) on the said date. Mr. G. Sharma, Standing Counsel, Home Depot, shall produce the relevant records relating to FT case number 42/Baksa, all capital Baksa, 2019. Wherein the London Tribunal passed the order dated, where they passed the impugn ex parte order, where they passed the ex parte order dated 2012-2019, declaring the petitioner, applicant oblique petitioner, to be a foreigner under Reference Act 1946. Okay. Copy of this order be furnished to Mr. G. Sharma.
Otherwise, Lordship, petitioner is seeking rehearing of the matter in the guise
That
of
will make some
review petition, Lordship.
This is an IA
Yes.
seeking release from detention. We have nothing to say at this point. Sister,
Yes, Lordship.
what time we should fix? 4 o'clock or?
By 3:30 or 3:45, like if we can spend. 4 maybe.
Okay.
3:45.
3:30.
3:30. Okay, Lordship.
Thank you, sister.
Thank you, Lordship.